David Oberliesen, presiding.
All right, good morning, everyone. You can be seated.
Good morning, Your Honor.
Okay, that's fine. Let's do it.
Apologize for the late start. I know I told most of y'all on Monday. We might have a little bit of a start today.
That's fine. That's fine. That's cool.
It's a violation of probation.
I understand.
Okay.
Let's see, make sure I have the right
But
docket.
revoke and terminate adjudication of guilty.
All right. Mr. Hardy.
Good morning, Your Honor. Ryan Hardy with Andre Clark. Mr. Clark's present and approaching. Your Honor, we just need to get this set for an evidentiary.
How quick are y'all looking to do that?
Your Honor, whenever we can, I guess the next available dates would be December 4th, and that's the only miscellaneous, I guess, that we have in December.
I think so, because I've got my 2 civil trial weeks, and then we have pre-trials, and then the holidays kind of cancel all of our Thursdays.
December 4th?
December 4th, 2 o'clock.
2 p.m. would be fine.
Okay. I mean, I know we have next week, but it's not enough time to get subpoenas out, so.
No. December 4th is fine with us, Your Honor.
At 2 p.m., right?
2 p.m. for a contested.
Thank you.
Thank you, Your Honor. That's all I have.
All right, that's with subpoenas. All right, thank you, Mr. Hardy. All right, Mr. Durrell.
Your Honor,
Morning.
may it please the court, Dustin Durrell. I'm covering for Miss Larissa Dudley today. She has Antron Coleman, 17 CF 1004. And Your Honor, Ms. Dudley is asking for the 17 CF case to track with, appears there's a new law case, 25 CF 2019. Looks like he's set for 11/6 for arraignment and 12/22 for a pretrial conference in that new case. She'd just like this to track along with that.
There's no objection.
New system's better, but it's slower. So, all right. I guess there's not really any reason to put it on the arraignment docket for next week with that case.
I don't believe so, Your Honor. I just know those are the dates she mentioned to me, so.
All right, let's go ahead and just put it on the 12. It's actually going to be 12/23 because he's in custody.
That's right, yes, Your Honor.
And that'll be 9 o'clock for pretrial to track with the other case, which is currently set for the 22nd, just because it hasn't been adjusted for him being in custody.
Understood, Your Honor.
All right, Mr. Coleman, we'll see you back on December 23rd. I'll actually see you next week for your arraignment in the other case, but this case will be on the 23rd of December.
Law case next week. And Your Honor, Ms. Dudley indicates she had a Sean Ruiz. I checked, it looks like he was set for today. There's been some conflict as to whether or not he was actually on the docket, though. I don't believe he's been transported, but she's asking for a continuance anyway. The next available miscellaneous, it looks like she's still
My
awaiting.
paper docket, but I'm seeing it here. Do y'all have? Maybe under. The order relieving the PD was just about a week or 10 days ago, so maybe that's. Not there either. Is he in custody?
I believe so, Your Honor.
I've got it, Steve. I mean, if Miss Dudley's not here, I'm not sure anything's really going to happen.
I know she has depositions this morning, that's why I'm here. I don't know how long they're supposed to last.
All right, what date was she asking for?
The next available miscellaneous, although if that's next week, I know she also said she's still awaiting BOP discovery, so
All
that
right,
may
let's
not
go
be.
12/4 at 9 o'clock, since it's not
12/4.
being set for an evidentiary.
Or at 9 o'clock. Thank you very much, Your Honor.
Obviously, I know she knows this and you know this, but if she wants to bring it in earlier for anything, if it's going to get resolved, we can certainly do that.
Yes, Your Honor.
All right,
I believe that's all she had.
all right, thank you, Mr. Duro. 12/4, 9 a.m. All right, who do we have next? Mr. Parnell? Okay, your client's not here.
Late rise or,
Say again.
I'm sorry, good morning, Judge.
Good morning.
Trey Parnell, on behalf of Gregory Austin. First, I'd like to apologize for not making it yesterday. If it's not on my calendar, it doesn't exist, and I don't know why it wasn't there, so I apologize.
I pretty much spend most of my waking hours sitting here, so just anytime you can be here, we'll figure it out.
Does the court
I
want
talked
to
about
wait?
yesterday when we finished about 6 o'clock, I may just build a bed underneath the bench and sleep here.
I
at
hope it doesn't
everything.
come to that.
It's just wasting my time commuting.
Doesn't look like it's much better today. Does the court want to wait until Mr. Austin arrives?
I think so, just because I don't think you've been here with him, because you just took it over, I know, the last time around, maybe?
Yes, sir.
So I just want to make sure that he's had a chance to be here with you.
We have a regular Zoom call scheduled with him weekly.
Okay.
So we've been keeping him in the loop, and I've had regular conversations with Ms. Brickman. So as soon as he gets here, we'll.
Well, I'll call it back up as soon as Deputy Williams tells me he's back.
Okay, very good. Thank you, sir.
All right. And Ms. Merrifield?
I have one I can address, Judge. I'm still waiting
Okay.
on the female inmate.
Hey, you look like someone else wrote your name and then crossed it off, and then you...
I did, Judge. I was waiting on a female inmate, and I also have an inmate that did not get transported. Bernie Merrifield on behalf of Dakota Madden. It's 25 CF 1868. It shows on the new Odyssey docket. It doesn't show on the old docket. It was filed 10 days ago. I don't know, or I don't believe.
Give me
that-
the name again?
It's Dakota Madden, Maddan, and it's 25 CF 1868. It was a bond reduction motion.
Is Madden available? Or?
He was not transported, which is
Oh, that's,
one of the reasons I crossed my name off, just kind of hoping that
Yeah.
it would happen.
I guess once he gets back, or once he gets here, we can,
Well, I spoke to ASA Leone, and she does not have the file with her, so I don't know if it didn't show on her docket. I can only,
The docket, it doesn't show my docket.
shows on the Odyssey online docket, and it was filed, Judge, so I guess,
the notice of hearing is here, I can see it. It was
Yes, sir.
filed on the 20th, so like you
yep,
said, 10
along with
days
the bond
ago.
motion. Is there an alternate date? I know the court calendar is getting a little congested. Could it be heard potentially Monday? I wouldn't anticipate it to be a very long hearing.
Any
It is
chance
a
we can do it this
reduction.
afternoon? Leonie?
No, there are victims involved in the case, and I would need to at least communicate with
Well,
them.
but he also has a right to have a hearing. He's set it 10 days in advance.
And there is a bond in this, Judge. I'm simply asking for a
A
reduction.
reduction.
Yes, sir.
What's the current bond?
The current bond is 125,000 between both counts. So I've got, count one is 25,000 cash or professional, count two is 100,000 cash or professional. I would simply be asking that count two be also listed as 25,000 cash or professional.
Well, if we can't do it this afternoon, I mean, I think we can just put it on for Monday. Is that
would
going to be
fine. I
sufficient
already
time? Are you gonna-
Suggested that to Ms.
I'm already here on Monday.
I figured you were.
I am.
That would be fine.
All right, let's put it for Monday, but if y'all can work out something for this afternoon, I know Ms. Leone, you'll be here, so you won't have a chance to reach out to anyone, so I guess we'll just put it for Monday at 9 o'clock.
Sounds good, Judge, and I will wait for my female to show up. She is.
Oh, you do have her now? Who's that? Because I don't have you on the docket at all.
No, sir, Judge. Brittany Merrifield, on behalf of Tricia Gatewood, it's 23 CF 1533.
This is my docket that was sent over at 4:12 yesterday.
Yes, sir. We entered our notice on the 13th of October. The public defender was relieved on the 13th of October. I did inform the public defender. He was also unaware that Ms. Gatewood was no longer his. If I could just have a brief moment, I didn't get to meet with her earlier.
Yeah, the order relieving the PD was on the 14th. 23 CF 1533.
Here, let me bring it down further. Thank you, ma'am.
Strange, because the cases that we added yesterday afternoon in court are on the docket, but ones that were set for hearing 10 days ago are not.
And Judge, we have reached an agreement in Ms. Gatewood's case, if I may approach.
Yes, ma'am. It's a great time to be alive.
And Judge Tricia Gatewood in 23 CF 1533 is withdrawing any previously entered plea as she is entering an admission to the violation of probation to the terms that are listed in the agreement. And one specifically, Judge, is that she will be maintaining her withhold of adjudication in this case.
So it's a modification, so it's not, we don't have to talk about downward departure, right?
Yes, Your Honor.
What was the basis of the violation?
There was a revolver and ammo found in her residence. Probation's recommendation was to reinstate with CC sanctions, but Ms. Merrifield provided numerous letters and recommendations. She's active in AA, Celebrate Recovery, and volunteering in the community. CC would handle that, so we agreed to work with the application with the OCJ.
Okay.
She had also been active in the ECLC classes while she was in jail, so she did use her time appropriately and did not stop any of the good positive treatment that she had obtained prior to being incarcerated.
How much credit does she have?
She has sufficient credit. She would be released today, so she
Okay.
would need to report for those sanctions today.
Okay. Ms. Gatewood, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Tricia Marie Gatewood, 11/13/1976.
And put your hand down. All right, Ms. Gatewood, as announced, you're here on a violation of probation in 23 CF 1533. I've been given a plea agreement between you and the state that would have you admit that violation, in return reinstate and modify your probation with the 60 days in county jail, which, from what I've just been told, you've already served. So you'll get credit for all time served. That's a condition of your probation, but it's basically completed already. You'll have to do all your original terms and conditions that were previously imposed, plus a $50 VOP fee and $50 cost of prosecution. Based on the agreement that you've made, the court would still withhold adjudication, but that doesn't happen twice. So let's make sure we don't have any other slip-ups. All right, is that what you want to do here today? Okay, and did you go over this plea agreement with your lawyer?
Yes.
Did you understand and sign it? Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Suffering from any mental health issues? Anyone force, pressure, or threaten you in any way to enter this plea?
Nope.
Anybody promise you anything in return for your plea? You understand that by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove that you did so. Okay. And do you understand you're waiving any potential defenses that you may have? Yes, okay. All right, and what is your plea to the violation of probation? Are you admitting or denying?
Admitting.
Okay. I'll accept your admission as freely, voluntarily, knowingly given. Reinstate your probation, modified to include the condition of 60 days in county jail, credit for all time served. Complete all your original terms and conditions that were previously imposed, plus the $50 VOP fee. $50 cost of prosecution. You'll have to talk to probation before you leave the room here today, and then you have 30 days to appeal the judgment and sentence.
Thank you,
All right.
Judge.
All right, thank you. Have
That
a
should
good
be
day.
all I have this morning. All right, so you're gonna step.
All right, Mr. Keach.
Judge, may we approach real quick on that?
Sir.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main.
So, Mr. Keach, we've got James
Terrell.
Terrell, is he here? Okay. All right, this is James Terrell. It's 21 CF 924 and 1577. I believe there's a new evaluation report. I haven't seen it, Mr. Keach. I know we're setting it for a hearing where it's going to be addressed, but I don't see if it's been filed.
Your Honor, Dr. McDonald emailed it to the parties Sunday evening and appeared to have e-filed it with the court, so it might be in the portal abyss.
Maybe.
But regardless, I would be moving to set it for a hearing on the evaluation.
Oh, here it is. It's in the other, I was looking in one case, it was in the other one.
That's where I found it.
Okay. All right, so we're going to set it for December 4th?
I think if the court has availability on its December 4th docket in the afternoon, we could
Put it at 2
secure.
o'clock.
2 o'clock?
If we could just, as we talked about at the bench, confirm that the doctor can appear that day. Again, we're fine by Zoom to make it a little bit easier. I just don't want it to be a situation where we don't find out she can't be here till the last minute. So follow up with that, Mr.
I will
Keach.
email her, I'll copy Ms. Guzman on that in the state, and that way we can all be apprised of where we go from there.
And if it has to be moved because of that, we'll find time. In fact, we somewhat inadvertently put some cases on the 5th. So we can maybe use that as a day, but we'll coordinate it if that doesn't work on the 4th.
Yes, sir.
But that's where we'll put it for now. So that's December 4th at 2 o'clock for the competency hearing.
Yes, sir. And that's all I have today. Maybe excused?
Yes, sir.
Do you have something for me? Is that it?
Sorry, Mr. Parnell, I'm kind of snickering to myself, but every lawyer who's waiting seems to like to sit right behind my deputy, and then I don't know you're here. I'm not sure, have we, he's, okay, he's
I
here.
just spoke to him.
Okay, perfect.
He should be in here in just a second. Here he comes. Mr. Austin is approaching. Trey Parnell for Gregory Austin.
Okay, we were set for a pretrial conference yesterday. What do we want to do with Mr. Austin?
Judge, just to advise the court, I believe that we have received all the discovery from his previous representation. We had filed a motion that the court signed the order recently to receive the 5th and 7th amended, which is the DCF reports and forensic videos. State Attorney's Office contacted us and said that they are mailing that to us, and as of yesterday, we hadn't received it yet. But we should have it this week, I would hope. We also filed a bond motion a couple of weeks ago. We need to get that set for a hearing if the court's going to allow it, just to put that on your radar. And
I guess I think we had one with previous counsel since I took over sometime this year. I'm not sure of what date it was off the top of my head.
I believe it was in February.
January, February.
It was early on. That just
It's for a reinstatement.
Okay. And, I mean, I haven't seen the motion yet, so,
It is similar to the first one.
okay. Well, just my concern is some substantial change in circumstances since the last one. Because I think that was part of the issue that came up during that hearing. I could be wrong. I think I'm right.
It was, you said if there were more delays, you would entertain another one, and it's been 8 months.
Well, I understand, but I think changing lawyers on your side might be part of the cause of the delay,
I
but,
didn't change them until July.
okay, well, I can only entertain things that are filed and set for hearing, Mr. Austin.
I understand.
So I understand.
We'll get in touch with your office
Okay.
on that one, Judge. Also, Ms. Brickman and I have had several emails and conversations about the case.
Oh, Barrickman, okay.
I beg your pardon?
Barrickman.
I
I
apologize.
thought you were saying some, I didn't know who you were talking about for
No,
a second, so Ms. Barrickman.
Seems like I've heard it said both ways.
She's been called that quite a few times, I'm sure.
I'm sorry, I will not do that again.
I probably called you that back when you first started, too.
Well, so anyway, we are moving the case forward. I know you had some concerns when I first got on the case about moving it because it is an older case, so we are diligently pushing forward on this. And once we get the 5th and 7th amended, we should be able to start moving forward even more diligently than we are now.
All right, so what we'll do is we'll put it on December 23rd for the next pretrial. I know you don't come over here a whole lot, at least my division, Mr. Parnell, so I do my pretrials Monday out of custody, Wednesday in custody. Otherwise, we're here until 9 o'clock at night.
Okay.
And we were still here till 6 o'clock last night, so.
And one other issue, Mr. Austin, we'd signed a waiver of his appearance at these pretrial conferences, and he would like to exercise that if the court is open to it. Like I said, we have a video conference with him every week, so he's up to speed. I just don't know what you're.
I don't have any concerns with it as long as it's his decision that he's making and he can revoke his decision at any point to show up for pretrial conferences, especially when this case is old and he's concerned about the age of the case as well, then I want to make sure it's progressing. So as far as the next pretrial, I don't have an issue with that, but we'll kind of see where we're at. If anything is going to be filed or done ahead of that, certainly, Mr. Austin, just make sure that you indicate to them that you want to be at any particular hearing. Obviously, we're going to have a bond hearing. I would expect you to be here. But as far as a pretrial, if you want to waive your appearance, you're free to do so.
We'll just file something then before the next. Okay. Thank you, Judge.
All right, thank you.
It's good to see you.
You too. Travel safe back.
Thank you.
Dan? Sure. It's not about him, okay. All right, thank you, Mr. Austin. Who's that on? Who is it? Golly, we were just talking about it. I think I received it. I want to say it was on my desk. Just kind of, but I put it to the side because I knew we had some time before it was coming up. Okay. And have you given one to the state? Okay. Okay. Yeah, I could have swore it was sitting on my desk. Could have been somebody else. All right, thank you. All right. And who's that? Oh, Jay Williams is on it? Oh. What was the name you told me? Cohen?
We've not been
Oh, it's with a
appointed
K.
yet.
It's. On page 3. Yeah, there it is. Problem is, they've got Miss Rivers, one of her cases mixed in with the private lawyers. So that's why I was not finding that, because I didn't go past that one. All right, is William Cohn here? All right, you're William, William Cohn?
Yes, sir.
Am I saying that right?
Yes, sir. Code.
Okay. You're here 24 CF 2396 regarding a violation of probation. You're not currently represented. Do you intend to hire a lawyer, or were you going to ask for a public defender to be appointed?
Yes, sir.
Okay. So what would you like to do with your case? Are you going to enter an admission, or do you want to set up for an evidentiary hearing?
Sure.
Well, that's probably why you need to talk to a lawyer. I can't give you advice as to what to do. All right.
Judge, if I can just stick my 2 cents worth in. I looked at it when I saw his name on the docket because it looked like something I might be appointed to.
Okay.
And my notes on it were, it looked like what they were talking about was a reinstatement. So I think maybe that's why nobody's worrying about appointing a lawyer on it.
Okay. What's the offer?
May I have his last name again, please?
Cohen with a K.
Oh, with a K.
Yeah, that was, well, I couldn't find it either. I thought I was looking under C. It's listed
Yes, I
under
have it.
no attorney, so I've got his number 9 on my docket, but I don't know if that's the same one you all have.
And it is a modification, reinstatement, Your Honor.
Okay.
That's the recommendation, and I would adopt that. Constructive.
It looks like it's a positive UA.
So the recommendation from probation is that he be reinstated to probation and be ordered to complete 50 hours of community service work that was included in the alternative sanction program. So just reinstated with the addition of the 50 hours community service.
I guess my concern, Mr. Cohen, is you're on probation. You were given an alternative sanction due to the fact that you had a positive UA, and then you didn't do it, according to this affidavit. Now, the recommendation is give him the same penalty that was on the alternative sanction that he didn't do, allegedly?
He complied with the curfew also.
Did do the community service.
Yeah, that's the only thing he didn't do. He's scheduled to terminate on March 2nd, 2028.
All right, so, Mr. Cohen, did you understand the recommendation?
Yes, sir.
Okay, so what would you like to do? Do you want to talk to a lawyer? Do you want to admit your violation? Do you want to set it for a hearing?
Statement.
So you're going to admit you violated and you want to take the recommendation they've given? So that would be 50 hours of community service work at a rate of 8 hours per month, abide by the curfew for 30 days. Oh, I'm sorry, they're saying you've already done those things except for not the 50 hours. So it's basically just to put you back on probation and add 50 hours of community service. Do you do any community service as part of the alternative sanction? Mr. Cohen, do you know if you did any?
I do any, no, sir. I didn't do any community service.
Are you going to be able to do the 50 hours of community service at a rate of at least 8 per month? Okay. Do you want to admit and take that? The 50 hours?
Yes, sir.
Okay. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. State your full name and date of birth.
William Fred Cohen, 2/22/1975.
Okay, Mr. Cohen, you're here for a violation of probation like we've talked about. The recommendation is for you to do the 50 extra hours of community service. That would be at a rate of 8 hours per month. Do you want to admit your violation and do that?
Yes, sir.
Okay. Do you understand, well, first of all, are you under the influence of any alcohol, drugs, or controlled substances at this time? Any mental health issues that you're suffering from at this point? Do you feel as if you're being forced, pressured, or threatened in any way to take that admission? You feel like someone has promised you anything in return for your admission? Do you understand if you enter this admission and reinstate your probation, there's not going to be a hearing where the state would have to prove that you violated your probation? Okay, and do you understand that you're waiving any potential defenses you may have had to the violation of probation? And so what is your plea? Are you admitting or denying your VOP? I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to reinstate your probation. You're going to have to do all of the previous terms, plus the 50 hours of community service at a rate of at least 8 per calendar month, starting in November, since today's the 31st. There's also a $50 VOP fee and a $50 cost of prosecution, and that'll be added to the monies that you do owe. Do you have a withhold or an adjudication?
He has prior felonies in the,
Okay.
although a modification would just keep whatever initially was done, either withhold or adjudication.
Okay. All right, so you're going to have to talk to probation before you leave here today. You've got 30 days to appeal the judgment from today. I would suggest, Mr. Cohen, don't come back on this case. I mean, you've been given an alternative sanction. You didn't finish that. Now you're getting another chance to do that. If it comes back, even on a technical violation that involves another positive UA, since this is a drug charge to begin with, I don't expect that we'll be talking about probation again.
If I may, Your Honor, based on what he scores with the 6 points of this violation, right now he is at 42.8 points. So should he violate, even with that technical violation, then he will score a minimum of prison time.
All right, so yeah, you're talking about over a year in prison if you come back on another violation potentially. All right. All right, talk to probation before you leave. I think I've announced everything. Are you missing anything? Previously guilty. I just wanted to make sure. Yeah, I can see that. I'm sorry. I looked it up. All right, talk to probation, and then you're follow their reporting instructions.
Yes, sir.
All right. All right. Anyone else you've got lined up, or? Okay.
Yeah, we do have Mr. Taylor, Your Honor.
Well, why don't we take our out-of-custody people so we can get them moving?
Yes, Your Honor. I mean, I don't think you have any others. Just that one, right? Is that the only one you show out of custody? I think that's it. Mr. Taylor?
I'd look at my docket, but it was wrong about a third of the time. So.
I don't want to say this is my last case again and then have 3 others.
It's just like when someone says, oh, just one more question.
Your Honor, this is Mr. Taylor before the court in 25 CF 273. Last time you were here, if you'll recall, there were some ambiguities in the report, Your Honor. Recommendation was outpatient treatment. All of us were looking for clarification on it. I did reach out to Mr. Sanchez. I have an email for the court's benefit if the court would like it. But basically what Mr. Sanchez says is that he's the one who actually does the training. They typically contract this outpatient treatment through this Lakeview Center in Pensacola. And then that's where he'll do his training, Your Honor, and it'll be coordinated through them. So that is what I'd ask the court to order. And again, I do have that email from Mr. Sanchez.
I could take a look. Yeah.
Yes, Your Honor. May I approach?
Yes, sir.
He's the one who would actually be doing the training.
All right, so it's in Pensacola?
Yes, Your Honor.
Okay. Have you talked to your client about that it's 2 counties away, where he'd have to go?
We'll coordinate the training. No, Your Honor, I had not had an opportunity to talk to him about that.
I just don't want to set it up for something he's not going to be able to do.
That's fair.
You want to take a minute to talk to him this morning?
Yes, Your Honor, I will.
Going to be
Can we
viable?
pass him, please?
Yes. All right, Mr. Taylor, he's going to come back and talk to you in a little bit, so don't leave us yet.
Of course, given he can't, and I don't know what the situation will be, Your Honor, I guess what I'll do is reach out to Mr. Sanchez and see if there's any alternatives or a way to do a virtual appearance or something like that.
Well, I think the good thing, at least from the emails, are willing to do it bi-weekly as opposed to every week.
Yes, Your Honor.
To save the trips. So it'll be a couple times a month, Mr. Taylor. So he'll discuss it with you, and we'll bring you back up.
All right, thank you, Your Honor.
All right.
Real quick, I know I have some obviously this afternoon that are, but everything else has a red sticker on it, so.
Okay.
All right, thank you, Your Honor.
All right. Why don't we take care of out of custody? Mr. Williams?
Judge, I have Mr. Lanehart. I've spoken with Mr. Lanehart, or Lanehart's family, and with the state. They have, this is one where we're waiting on an APD evaluation.
Okay.
They have had the meeting with APD, but neither myself or the state at least have an evaluation from them, or a report from them.
That's accurate, Your Honor. We checked the files, we checked the emails, we have not seen the report yet. The order was signed, and as Mr. Williams mentioned, he has actually met with them.
And the order back in early September.
Yes, sir.
Correct.
Yes, sir. I cranked out the order shortly after court.
Have you been able to communicate with them at all, Mr. Williams?
No, Judge. I was just waiting on the report.
Why don't we follow up just to make sure that they're going to get us a report sometime, or for all we know, they think they sent it over and it's sitting on somebody else's desk. I just want to make sure we're not, making sure we're being a little more proactive, because it seems like people's cases are getting delayed because we don't see the stuff that we need. So when do y'all want to put it back?
Judge, we can put it back on the closest available date as far as I'm concerned.
Well, I've got one next week. I just don't know if we're going to get anything by then.
Well, Judge, I can, I don't want them to have to wait around, but I can duck down, APD's in this building, is it not?
I don't think so.
No? Okay. In that case, I can't just duck down there and check on it.
Why don't we do this? I'll put it on 12/4 at 9 o'clock, but if you're able to get a copy of that order, or that report faster, then let's get it on an earlier docket as early as next week.
Yes, sir.
I just don't want to have him come back just to find out we still don't have a report next week.
Yes, sir.
All right. All right, so Mr. Lanehart, we'll see you back on December 4th, but stay in touch with your lawyer. We may bring you in earlier so if we can get you going faster with them. All right, thank you. Anyone else out of custody?
Mrs. Hutchinson entered a plea and was sentenced back on 925, she pled to adjudication of guilt, 60 days county jail with credit for time served, revoking term. It was on a possession paraphernalia. She'd originally pled to a lesser offense.
I don't know anything about this situation other than I read.
Rivers, do you have anyone out of custody? No? Trenton Stacy. Didn't he have something else today? I saw him on the docket again.
That one we did I did a notice of cancellation.
Oh, okay.
Yesterday.
Okay. Roselle, didn't we cover that? That was the switching to no contact, or no violent contact. I think we covered that on Monday. Paycheck.
In that one, Your Honor, Ms. Basso and I spoke about that before court. We weren't sure if we had, we brought it up. We weren't sure if we had finalized the discussion or not. In this particular one, we filed a motion to modify the pretrial release conditions. In this particular one, one of the victims had been reaching out to her.
I just read it.
Ms. Basso is okay as long as the child reaches out first and it doesn't involve discussing the case.
The state has no objection to that, Your Honor.
Have y'all talked to the other parent? I guess you all can't, right?
No, I cannot.
Right, so what exactly restrictions do we want to do because that's what the motion talks about.
That's why I remember, because I read it yesterday to make sure.
I don't know how we govern that the child has to initiate contact.
Okay.
This is by text, I believe, as he was reaching out to his mother by text. The child is 17, not a young child.
17. Doesn't he live somewhere else?
He lives in the family home, and she's in
Not here,
rehab.
but she's in rehab. That's right, she's in
rehab in
California.
California.
All right, I don't have an issue with it as far as the text messages go, but if you could get me an order, shouldn't be anything extensive, just so we have a separate court order as opposed to just the minutes on that, because could be confusing.
Yes, Your Honor.
All right.
May we approach on Mr. Taylor briefly, Your Honor?
Sure.
Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
I got the noise on.
All right, this is Mr. Taylor, Your Honor, recalled.
That's
25
CF 273.
Yes,
So-
Your
I'm
Honor.
sorry.
I
Go
believe the
ahead.
state has an announcement in the case.
Yes, Your Honor, based on conversation and new information that the state has received, at this time, the state dismisses the charges against Mr. Taylor.
Okay. Mr. Taylor, your case has been dismissed. You're free to go.
Thank you, Your Honor.
You ready for inmates, Mr. Maddox?
Yes, Your Honor. Your Honor, this is Mr. Shamar Anderson. Your Honor, I believe we're going to have a... Your Honor, this is Mr. I had him evaluated for drug court. Your Honor, it does sound like he's been accepted into the program. In fact, the state has sent me over a possible resolution on that front, Your Honor, so I want to discuss that a little bit more with Mr. Anderson, but it does sound like we're going to have a resolution in this case. He's currently set for an evidentiary hearing on 11/6, Your Honor. Would you prefer to leave him set on that date in case it does not resolve? Because he's going to plead into drug court if it does happen on November the 5th.
I would say just, we'll put it on the 6th for status, but if he pleads in on the
Okay.
5th, then we can just cancel it.
I just don't want the state to be in a position where they've sent out subpoenas, we have witnesses, and then they show up and we don't need them.
I would be fine with that. I've been communicating with the drug court people about him, so.
Well, let's leave it on for the 6th, cancel any subpoenas if you sent any out.
Yes, Your Honor.
And then if he's on, if he pleads it on the 5th, just cancel the hearing for the 6th.
Will do. Thank
All
you.
right.
All right, I'll come see
Thank you, Mr. Anderson.
Your Honor, forgive me, I thought we had just gone ahead and entered denials on his VOPs, but they may have been left set today. In any case, Your Honor, we would enter denials today. This is Mr. Bray before the court in 23 CF 2408 and 23 CF 2409, Your Honor. I'd ask for the December date to track the pretrial conference date with his new law case, Your Honor.
The new law is 1808.
Yes, Your Honor.
And that's already listed for the 23rd. So
Yes,
let's
sir.
put the two VOPs with the new law violation. That'll be December 23rd at 9.
Yes, sir.
Your Honor, may I please ask to actually be set this on a miscellaneous for a VOP evidentiary contested that will resolve the new law violation. Mr. Bray has a 5-year suspended sentence, so.
In this case.
In the violation case, in the probation, yes. So that's what I will be asking, and
When do you want to set that then?
it's up to the court. I can do it the December 4th or the date in January. Doesn't matter, it's fine.
Maddox?
January, Your Honor, just so I can talk with my client about it, prepare for it, and see if we can't reach any alternative arrangement, although I'm not, you know. January would be our preferred date, Your Honor.
I want to say, Your Honor, there is a miscellaneous, I think, on January 29th.
Does that 5-year suspended sentence, would you also be including the new law in that? It's cumulative global offer?
Yeah, it would be, yes.
Okay, all right. Thank you. 5 years
I
total.
don't have a calendar yet, but I can see it on my calendar. All right. You want the 29th of January?
Well, the other option would be what, December 4th, Your Honor?
It's February 5th, the next one.
I mean, I've got January 8th as an arraignment date. We could always put it on that.
In the morning?
Well, in the afternoon, we've been putting some miscellaneous after arraignments.
Yes, Your Honor, let's do that.
That's fine. That's fine, Your Honor.
I mean, we'll have the pretrial
months.
before then anyway. But.
Yes, Your Honor, that should be fine.
All right, so let's set January 8th, 2 o'clock for the evidentiary hearing.
Yeah.
I'm not even sure who made this in the first place, but we'll have to do another one soon for it. I don't think it was, do y'all do this normally? Okay. Since we're pushing into those dates as it is.
I'll look at it.
All right, we'll see you back on December 23rd for your pretrial.
All right, thank you, Your Honor. And then we said 1/8 with subpoenas, correct?
Yes, 1/8, 2 o'clock.
Sure. Just want to make sure that was you. They have an offer in Mr. Booth's case, 23 CF.
I'm Fountain, sir.
Sorry? Oh, Mr. Fountain, my apologies.
I'm sorry, Mr. Fountain?
Yeah, Jared Fountain.
Okay, one sec. Gerard Fountain? Yes. Revoke and terminate and guidelines. He scores 23.7 months.
27?
Yeah.
All right, Your Honor, we'll enter denial today.
All right, what do you want to set it for?
Um,
I mean, do you want to set it for an evidentiary hearing or no?
Not at this time, Your Honor. I would ask for the 12/4 date to see where we're at, and then after that, if we need to, that's likely what'll happen.
That's fine, Your Honor.
All right, December 4th at 9 o'clock, no subpoenas. It's its status. It's not an evidentiary hearing. All right, thank you.
Hey, Mr. Frazier. Your Honor, could we set this for 11/3 for possible plea or continuance, Your Honor? And we'd enter denial today.
All right, Mr. Frazier, we'll see you back on Monday for a possible plea. Otherwise, we'll set it for a new miscellaneous date.
Yes, sir.
All right.
This is Mr. Kenneth Garcia.
You said you wanted the score sheet.
Your Honor, we've reached a resolution in this case. Just need to get the score sheet. If we could just pass him until I can get that, and we'll have a resolution.
I have the score sheet.
All right. Let's ask Mr. Garcia to bring him back up for a plea.
Oh, you have it?
Yeah.
Never mind,
Oh,
she has it.
okay, then we won't pass him.
If I could just have a brief moment then, Your Honor. Okay. Sign right there for me then, sir. Mind if I date it for you? All right. May I approach, Your Honor?
Yes. Mr. Garcia, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth, please?
Kenneth Abraham Garcia, 82569.
Okay, and Mr. Garcia, you're here in 24 CF 2496 regarding a violation of probation. I've been handed a plea agreement between you and the state that calls for an adjudication of guilt, 120 days county jail with credit for all time served, revoke and terminate your probation, $100 VOP fee, $100 cost of defense, and then I'll give you 90 days to pay off your costs. Is that what you want to do today? Did you go over this agreement with your lawyer? Did you understand and sign the agreement?
Yes, sir.
And are you satisfied with your attorney's advice? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressure, or threatened you to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No.
Do you understand by entering an admission to your violation, there's not going to be an evidentiary hearing where the state would have to prove that you violated your probation?
Yeah, I understand.
All right, and you understand you're waiving any potential defenses that you had with that violation?
Yes, sir.
And also, do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Okay. And what is your plea to the violation of probation? Are you admitting or denying that?
I'm admitting it.
All right. I'm going to accept your admission as freely, voluntarily, and knowingly given. I'm going to adjudicate you guilty, 120 days county jail time with all time served credit, revoke and terminate your probation, $100 VOP fee, $100 cost of defense, 90 days to pay those costs, or you can try to set up a payment plan with the clerk's office.
All right.
Just give them about a week before you try to do that.
All right.
Do we think he's got the time to be released?
It would be close if he doesn't, Your Honor.
Okay. All right, and this is a guideline sentence. He scored 22.4 points. All right, Mr. Garcia, do I need his fingerprints? You already have them.
Was previously adjudicated, Your
Previously
Honor.
adjudicated?
Yes, Your Honor.
All right, then we don't need them. You have 30 days to appeal, Mr. Garcia. Have a good day.
Your Honor, this is Ms. Watson. I believe we still have to do a competency hearing for her, Your Honor. Has the court had the benefit of reviewing the report? Otherwise, I have one, Your Honor. But she has been recommended to be found competent to proceed. In my conversations with her, I do agree with that recommendation. I would be willing to stipulate to the report I received, Your Honor. That was from Dr.
This is a
Zink.
return, this is a return, right?
Yes, Your Honor.
Okay. Problem is, he's come in and I read them right away, and then we don't have a hearing for 3, 4, 5 weeks, and I don't remember them, but let me take a quick look at it. Because the ones that come from the
No, I'm fine.
Florida State Hospital always get emailed directly to me, so I can have a chance to read them.
Okay.
But this one came in October 6th.
Yes,
so
Your Honor.
I probably read it within the next day or so, and
We talked about it briefly on the 9th, but that was it, Your Honor. That sign right there for me. Should be released today.
Okay. What's the date? The 30th, right?
Yes, ma'am.
so the parties are stipulating that I can make the decision based on just a single report?
Yes, Your Honor.
Based on that, and I've reviewed, again, the report, I'm going to find that Ms. Watson's been restored to competency.
Yes, Your Honor, and we have reached a resolution in the case in that situation.
Thank you, sir.
Yes, sir.
All right, Ms. Watson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Angela Marie Watson, 5/30/1984.
All right, Ms. Watson, you're here in 25 CF 19 with a charge of burglary, third-degree felony, punishable by up to 5 years in state prison, and a petty theft which is a second-degree misdemeanor and therefore punishable by up to 60 days in jail. Do you understand that?
Yes, sir.
All right. As far as the plea that I've been handed between you and the state, it's asking you to plea as charged, adjudicate you guilty, which being a felony conviction on the burglary, credit for time served, 515 court costs, $150 cost of defense, restitution of $2.65
Yes, Your Honor.
to the Dollar General, and 90 days to pay those costs and restitution.
Okay.
Okay.
So I'll get out today?
She will, Your Honor.
Yeah, it's not
Okay.
even, it just says credit for time served. It doesn't
Yeah.
say a number of days, so.
Correct.
All right, yes, unless there's something else holding you, I don't know.
No.
You don't have any other cases with any other division, or?
No, sir.
Okay. All right, is this what you want to do today, Ms. Watson?
Yes, sir.
All right. Did you go over this plea agreement with your lawyer,
Yes, sir.
and did you understand and sign it?
Yes, sir.
And are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
I have schizophrenia.
Okay. And that's part of what they've talked about in the report, is make sure you stay on your medications and everything.
Yes, sir.
Because you seem very lucid here today, and you're understanding everything,
Yes,
right? Okay. Any issues with that, Mr. Maddox?
No, Your Honor.
Okay.
She's improved greatly since we
Okay.
last spoke.
All right.
Can I ask where I'm supposed to pay that $2.65 to?
Since it's restitution.
It's restitution, go to the clerk's office, because she's done on probation.
Court need an address, Your Honor?
Yeah, paid through the clerk. I'll
Okay.
order that.
Can give the court an address if needs it, just to be safe.
Okay.
Dollar General at,
I don't know if she just goes into the Dollar General and tries to give them $2.65. They're not going to know what to do with it.
Yeah, that's why.
783 North Ferndon, Crestview, Florida, 32536.
If she pays it through the clerk, there's a cost. So the fee would be more than the restitution.
How it is.
Yeah.
All right. I'll let you try to pay them directly, ma'am.
Yeah.
Otherwise, you're
Oh, you pay
paying
them
a
directly?
fee that's bigger than the restitution if
Yeah.
I do it the other way.
Well, she may be trespassed from there, Your Honor. It's been a while since I've looked at that particularly, but she may be trespassed.
I think she can send it in the mail then.
Okay.
I don't want to have her get charged $3 to pay $2.
Okay.
Thank you, Your Honor.
All right. I think I left off with, has anyone forced, pressured, or threatened you in any way to take this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that by entering a plea, there won't be a trial of any kind.
Yes, sir.
And you understand you're giving up your trial rights, which are on page 2 of that agreement that you've signed.
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation.
Mm-hmm.
Yes?
Yeah.
I understood what you said.
Yes,
I just wanna
sir.
make
I'm
sure it's
sorry.
clear for the record. All right. And what is your plea to the burglary and the petty theft?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty. Give you credit for time served, 515 court costs, $150 cost of defense. I'll give you 90 days to pay those costs, or you can set up a payment plan with the clerk's office and then pay the $2.65 restitution to Dollar General.
Okay.
All right.
Okay.
All right, I just need your fingerprints, Ms. Watson, and then you've got 30 days to appeal. Have a good
Your Honor,
day.
if I may, just for the convenience of the court and for the state, Your Honor, Lynn Banks was also in a similar situation, Mr. Anderson. We have him currently set for an evidentiary hearing. It would be the same thing with him. He would be pleading.
When is that set?
11/6, Your Honor.
Okay.
He'd be pleading into drug court as well, and I believe the state has been made aware of that one as well, Mr. Banks.
Yes, Your Honor.
Then I would ask for the same thing, status date for 11/6, just so that subpoenas aren't sent out and not needed.
Cancel the hearing if you please. in
Yes, Your
drug
Honor.
court.
Thank you.
But it's not going to be an evidentiary hearing that day.
Okay. Green?
Mr. Kleins? Wasn't there a case I gave to Mr. Klein's yesterday that we set for today?
Are you busy doing something?
Just gonna go talk to Greg.
Watley?
Okay, that's.
Okay.
She in custody?
No,
Okay.
I'm not okay with it. So, I thought it was only.
All right, so, Mr. Klein's, I know you've got your normal cases, but
That's his one.
is this Miss Watley?
This is Miss Watley.
Okay, were you informed of it, Mr. Klein?
I was, as soon as I
Okay.
walked in today.
Since I knew you were gonna be here, I figured and let you get going on it now.
I think we're going to be able to get this resolved today. I just wanted to clarify, this is in the proper division. I know the order appointing my office was signed by Judge Stone in the list division too. But the plea was originally entered in this division. The violation and the notice to appear indicate this division. So I just want to make sure that, and Ms. Leone's listed, but Mr. McKinney's listed as the public defender, not Ms. Rivers. So, kind of all over the place.
I'll do 11:29. She needs to go.
I was, quite frankly.
This is 22 CF 733, right?
Yes, Your Honor. Yes.
I've got an order where I signed it. I think that was just yesterday morning.
I think it's in this division. I think it's correctly in this division. It's just, there was just enough confusion in the internet. So, but I was gonna ask the court if we could pass Ms. Watley. I believe we're gonna get this resolved today. I just asked probation to confirm the restitution balance that is currently due. So if we could pass Ms. Watley, we can pass her to the afternoon. I've got a couple cases on this afternoon too. Or if we get it resolved and we get everything worked out this morning, we'll call her back this morning. But
Yeah, it was up here originally, so I think maybe because Judge Stone didn't sign the one, obviously I signed one yesterday appointing you. But maybe they just put the wrong people on the bottom as far as who to copy.
I even looked at the CC list and it lists the south end of the public defender's office, but.
And prosecutor.
But then my assistant, so.
All right, let's pass Ms. Watley so you can talk to her and maybe
Okay.
resolve the case.
Yeah, we're working on that right now, Your Honor.
Okay.
Okay. Yeah, you're gonna
Go back, we'll bring you back later today.
Your Honor, this is Mr. Lee. He is before the court on a motion to reduce bonds. I talked to Ms. Leone this morning. This morning, I received an email from the alleged victim in the burglary case asking to drop the charges. Based on that email, I believe the state would stipulate to the bond motion or have no objection to the bond motion.
That's correct. Yes, Your Honor.
Now, in the bond motion, I did ask the court to reduce the $100,000 bond to a $10,000 cash or professional bond. I would ask that the court reduce that to a $10,000 signature bond. However, I would still think it's appropriate for the two $50,000 cash or professional bonds to be reduced to $5,000 cash or professional, because those are independent of the burglary charge. So I'm ultimately asking the court to set a $1,000 cash or $10,000 cash or professional bond, 5 on I believe it's the 1170 case.
1170 is the burglary.
Okay, then 5,000 on the 1171 case, 5,000 on the 1154 case, $10,000 signature on the 1170. He's already been ordered to wear a GPS monitor. We're not asking the court to modify any other special conditions, simply just to reduce the current bonds to essentially a $10,000 cash or professional bond, plus $21,000 in signature bonds.
What's the state's position?
I'm just objecting to the signature. I would do 10,000 cash or professional. I understand the victim made that statement via email. I haven't had the chance to follow up. I just got the email this morning from Mr. Klein. And I said I would agree to the cash or professional and with the GPS.
That's fair. I mean, I'll, however the court wants to rule, I mean, certainly. Still got my card.
a $50,000 bond on a marijuana charge?
Yeah, when I was writing the motion, I was like, well, it's like 1996 all over again, you know? Like,
Oh,
I thought it was unusual.
I don't think you were practicing back then, Mr.
I wasn't, but I, you know, I knew some people back in the day.
Take it now.
Yeah,
It was 223 grams, so that probably explains it a little bit.
It's a lot. I mean, but I also know that there was an individual in the South End that pled to probation for 2 pounds of marijuana in the past couple of years, which wasn't my case, but I was very surprised.
Maybe there was an evidentiary issue.
I'm sure there was something I didn't know about, but
All right, so Mr. Lee, based on what I've heard and the somewhat stipulations, what I'll do is $5,000 cash or professional on the 1154 case, $10,000 cash or professional on the burglary case. I understand that may be dismissed at some point, but it isn't yet. The state has to certainly verify what's going on with the alleged victim in the case, and then the problem with the 1171 case is it's 3 different counts. So just to make it less messy, I'll do $2,500 on count 1, which is the drug charge, $2,500 on count 2, which is the carrying concealed weapon, then an ROR on the resisting.
those are cash or professional?
Cash or professional, yes, sir. And then the GPS monitor, as discussed, at $1 per day. And I'll have to check in with pretrial supervision, I'll say once per month by phone.
And because of the nature of the order, we'll go ahead and get the court an actual order on this, so that.
I think that's always the better idea.
I agree.
Because sometimes things don't work as fast if they don't have an order.
Yes, sir.
Your Honor, I would ask no contact with the victim, witnesses, and co-defendants.
In all cases?
Yes, Your Honor.
Okay.
There's no objection from
No
this.
contact with the alleged victims, no contact with witnesses.
All right. And
And co-defendant, I think one case.
There was a
In
co-defendant?
one case, he has a co-defendant.
Which one is that, just so it's clear?
I think it's the distribution case, 20, I'll get it. I can state the name of the co-defendant is Tyshawn Morris. And the case should be the 1171 for Mr. Lee.
All right, Mr. Lee, no contact with Tyshawn Morris. Do we have him here today? Yeah.
Fine. Mr. Lee was just advising Mr. Morris and him are in the same cell. So he plans on bonding out, so I don't really know.
Well, I don't think I can have a no contact with someone that he shares a jail cell with, but if you're to bond out, no contact.
Fair enough. If released on bond, no contact with Mr. Morris.
And I apologize, Your Honor, the case in which Mr. Morris is the co-defendant for Mr. Lee is the 1154, not the 1171.
Okay.
All right. And so Mr. Lee is clear, I gave him today, because he was in court yesterday as an inmate, and so yesterday the court continued all of his cases to the 1223 docket. I have given Mr. Lee notice of being in court on 1222 at 9 o'clock if he is released on bond.
Okay.
So-
You understand that, Mr. Lee? Can you focus on up here what we're talking about? Because if you don't show up on the 22nd, which is your new court date of December, instead of the 23rd, you could end up with a warrant and back in jail. I'm not trying to sound threatening, I just want to make sure you know what day to be there.
All right. All right. Call my office when you get out. Okay?
All right, if you can give me that order today, I'll sign it.
Absolutely.
Mr. Clemens.
Your Honor, I need to step out. We're 2 seconds away from getting Mr. Marshall a plea agreement, but I need to confirm that there's a bed available to this particular program, so I'll step out real quick.
All right, just tell us when you're ready to come back. Yes, Rivers. Oh, that's right, there's that one on the second page. Private, who did we have yesterday? It was listed as self. I think it was Mr. Maddox. So it came up in a different section.
And Your Honor, I call myself printing out the docket from this morning that was sent.
He's number 6 on the docket. This is the one where it says you're mixed in with the private counsel.
Oh, okay.
So it's on my page 2, number
Yes.
6.
Yes, Your Honor. This is Kenneth Stewart. This is 16 CF 2231, and we're going to enter a denial at this time.
All right, are you wanting to set it for a evidentiary hearing?
Not at this time, Your Honor. If we could continue it to the next court date,
12/4?
that'd be fine, Your
All
Honor.
right, December 4th, 9 o'clock, no subpoenas.
Thank you, Your Honor.
Morning, Judge. What's your name, sir? Okay.
Mr. McPherson.
Judge, Mr. McPherson's alleged to have violated by failing to pay some money and do community service work. I provided proof of the community service work to the state and probation, which leaves him in a situation where it's just failing to pay money. If you'd like, ma'am, I can show you the log.
I saw that. I just don't know what probation said about it, if that's okay, complies.
Well, I sent it to probation as well. Ma'am, do you have any information, position on it? I have where it was sent to Jacqueline P. Johnson. Received, this will need to be shown to the court as his termination date was last October of 2024. Therefore, he's no longer in the jurisdiction of probation. If you want to look at that, I can present the email to the court.
This is Miss Johnson writing?
That's her
Yeah.
signature or her electronic signature down there.
Okay. It doesn't really answer me.
Judge, what I'm suggesting, since it seems to be just monetary, is that, especially since his probation is terminated, the court simply issue a judgment for the amount or send it to collections.
How much is it?
Looks like in 22, 194, 665, 195, 615, 196, 615, 197, 615, and 198, 615. And actually, Judge, in an abundance of caution to make sure I'm not reading it wrong, because the numbers don't line up directly with the heading. Is that correct, ma'am? He didn't pay
Except for the
those
Watley.
amounts in his mouth. It's still together. That's correct, Judge.
What are you suggesting, just unsuccessful termination with a judgment?
Yes, sir, I guess that would be appropriate.
Yeah.
I would agree with that, yeah.
As opposed to a plea to a VOP, because it's all monetary.
Yes, sir.
Does that come out as separate judgments for each case? Okay. They're all gonna go in this, I just don't know how y'all operate that.
Generally.
Using a calculator here. I added up quickly, it looks like about $4,355.
Yes, sir.
So
Yeah.
technically, he's already terminated, right? 10 days ago? All right, so unsuccessful termination, all monetary to judgment against Mr. McPherson. 615 in each case, except for the one that was 665, so it comes up to a total of $4,355.
Thank you, Judge.
Just to make the record clear.
I don't know if it was adjudicated at the time of the plea. I would ask for an adjudication.
I think he was. He's got.
Judge, my file reflects that he was.
Yes.
It is?
He was already adjudicated.
Okay, thank you.
All right, thank you,
Judge.
Mr. McPherson.
So you should be getting out today unless you got something else holding you.
Your Honor, this is Desmond Porter. He's before the court on 25 CF 137 for a violation of probation. We're going to enter a denial at this time and ask for the December 4th court date.
All right, without subpoenas?
Yes, Your Honor.
All right, 12/4, 9 o'clock. I'll see you back on that date, Mr. Porter.
Your Honor, this is Pablo Portugal. He's before the court on 21 CF 748, 21 CF 749, 21 CF 750. We are going to ask the court to continue it to 12/4.
For evidentiary hearing,
No, ma'am. No, sir.
date?
It's fine for this is the first time, I think.
Oh, when you said continue, I figured this was the first time, or the second time up.
Yes, Your Honor.
Okay, 12/4 at 9 o'clock without subpoenas.
Your Honor, this is Jared Riley. He's before the court on 22 CF 1745 for a violation of probation. We're going to enter a denial at this time. He also, I believe, has a case on for this afternoon.
That's correct. He's also on the arraignment docket, Mr. Rivers.
I thought I remembered his name. I'm trying to look it up, but again, the new system, a little slow still.
So, Your Honor, he is going to enter a denial at this time.
You want to just handle his afternoon case? Oh, you can go.
They happen to have the information
His
here.
arraignment case for the afternoon. All right, so that's going to be 25 CF 1707.
Your Your Honor, we're going to enter a not guilty plea at this time and request trial by jury.
Where do you want, you don't just want to put him on the next pretrial for both?
Yes, Your Honor, we would request putting him on the next pretrial docket.
All right, December 23rd at 9 o'clock for both this case and the one for this afternoon.
Thank you, Your Honor. Your Honor, this is Ashley Roberts before the court on 24 CF 29.
Roberts.
I'm sorry?
Ms. Roberts?
Yes, sir.
Up here, please.
Yes, sir, sorry. Before the court on 24 CF 2909 on violation of probation. We're going to enter a denial at this time. She also has a new law violation set for this afternoon. And Your Honor,
Go ahead, I found it's 25 CF 1923.
we're going to enter a not guilty plea, Your Honor, and request trial by jury.
All right. Let's put both cases to run together on December 23rd, 9 o'clock.
December 23rd. And get you into Joanne Burgess. Remember that's the one I told you in Walton County? The funeral. Your Honor, this is John Saber before the court on 25 CF 866 on our motion to set bond. Mr. Saber is currently in the Okaloosa County Jail and has no bond on the charges of possession of controlled substance, possession under 20 grams, driving while license suspended, and possession of drug paraphernalia. He has ties to the community. He's resided in Okaloosa County most of his life. He's asking the court to reinstate his previously revoked bonds or assess bonds of similar amounts.
His position.
The state objects, Your Honor. He was out on bond in 25 CF 866, where he was charged with possession of controlled substance and paraphernalia. After he was released, within 2 months of his release, he committed this other crime. It's a burglary of a dwelling. It's charged as an attempted burglary because he tried to get in while a person was inside. And the person inside was able to call 911, and eventually they arrested Mr. Saber. The defendant scores 53 months DOC minimum guidelines.
How much?
53 months. And the offer the state has made for both cases is guidelines. He has 2 prior felony failure to appear conviction, and his prior record alone is 53 points. That's just the prior record. The prior record includes grand theft, dealing in stolen property, 2 convictions, trafficking in drugs, heroin, burglary of an occupied structure, possession of burglary tools, resisting officer with violence, possession of controlled substance, grand theft of a motor vehicle, possession of firearm by convicted felon, and 41 misdemeanors, 3 misdemeanor failure to appear.
Anything else, Ms. Rivers?
No, Your Honor.
All right, motion is denied. Based on criminal history, based on being out on bond when committing, there's probable cause that he's committed a new law offense, which includes the attempted burglary, burglary tools, possession of controlled substance, smuggling contraband, resisting, false ID, theft, another drug charge, 3 counts of paraphernalia. So based on the prior history alone, I mean, that he scores. Your motion is denied, Mr. Saber. He's got have y'all filed an information on the case for this afternoon?
The burglary, I believe I have, yes.
Yes, here it is.
Yes.
What's the paperwork? You got anything on that yet?
In Your Honor,
And
on
let me just correct myself, because now I'm seeing the information. In the information, the state didn't charge the paraphernalia counts and only one of the possession of controlled substance, so it's 7 counts instead of 11.
Yes.
In Your Honor, we're entering a not guilty plea and requesting trial by jury.
Okay.
We're asking for the 12/23 court date.
All right, 12/23 for both cases.
Thank you, Your Honor.
Do you have any paperwork on that yet?
Nope, not yet.
All right, there ain't gonna be none. Just let him. I want to see the video, because I know there ain't gonna be no video either. I want a discovery
Of course.
of the old one, of this one,
Mm-hmm.
and the one prior to that. The one driving that they threw out for lack of evidence. Can you get that one too?
We'll discuss it.
Okay. And find out why that's reopened. It's on the clerk of court that that case is reopened.
Okay.
For whatever reason.
Okay.
When are you gonna be up there?
All right, Mr. Saber, she'll come out and talk to you.
Yeah, I thought Mr. Smith was next. Your Honor, this is Chayton Trulove before the court on 24 CF 60. It does say status on the docket, but it's actually a motion.
We talked about the motion yesterday, right?
Yes, Your Honor. And I filed a motion to take depositions. And Your Honor, under the Florida statute 92.556B, it says, it talks about, well, 6A, it says in any criminal proceeding, to take a deposition of a victim of a sexual offense, a person under the age of 16, we have to file a motion, you have to have a hearing, and here we are. It does say that under 92.556B that there's a presumption if the person is under 12 that the court would not allow a deposition, but in this particular case,
I think there's a presumption that it's not appropriate.
Right.
Doesn't mean it can't be done.
And in this particular case, the alleged victim is 13. And under 6B3, the court's to look at the relationship of the parties. In this particular case, they are half-brother and half-sister. 6B2, the nature and duration of the offense. That is an issue that my client has questions about. He believes there needs to be some clarification, and that's one of the reasons that he would like a deposition, because there is some vagueness in the forensic interview. There is a forensic interview. Yeah, we're getting there. And Your Honor, also some of the concerns that we have, and with not reading like every single thing here under 92.55, because the court can read it, there's no need for me to read it.
And I read it yesterday after we talked about it. I read it last night.
Yeah. Some of the concerns we have is you can't cross-examine a forensic interview. You can't, it's an interview where they ask them, will you tell the truth? It's not sworn. So it's not sworn testimony. It can't be used for impeachment. So there's that issue. So there's a number of different issues that come into play. So we feel like a deposition can be necessary. Another thing that the statute talks about is the age and mental age and maturity of the victim. And I noticed in the forensic interview and in the video of the officer that the officer did, she seems quite mature when she's talking to them. You know, obviously it's a distressing subject, but she seems to handle it pretty well considering the topic. So I don't believe it would be excessively distressful for her, and we would just ask the court to consider allowing us to take her deposition.
Your case, right, Ms. Basso? Can I get you to come up to the microphone?
Your Honor, as we previously stated, the state is opposed. 92.55 was designed to provide some protections for victims or alleged victims of sexual assault, especially when they're children. In this case, the child victim was between the ages of 6 and 10 at the time it's alleged to have happened. She was 11 when she disclosed. She is, of course, now 13, as Ms. Rivers mentioned. According to the statute, the court must make any ruling one way or the other whether or not that deposition can be taken. Your Honor, in this case, one of the things the court should consider, according to the statute also, is whether or not the information available is obtained in other means. The CPT in this case, we believe, was detailed, and the child did disclose the events that she's alleging that happened, how he would entice her to do it, what he'd ask her to do, that it occurred in the home. Those details are all provided in the time frame. As far as the reliability of the CPT, Ms. Rivers is correct in saying it is not a sworn statement. However, there is the indicia of reliability that in the CPT, the child must acknowledge that the child agrees to tell the truth and that they know the difference between the truth and the lie. So the child has stated that she will tell the truth and speak basically only of events that occurred. So we do believe that the indicia of reliability is there. Additionally, the method of questioning is an open-ended question. The words are not put in the child's mouth. The child does go ahead and provide that.
I guess that's my concern on both sides, that both lawyers are kind of proffering what happens in this video instead of just, shouldn't the court just review the video to make it its own determination, or do I have to take everyone's word for it?
Your Honor,
I've seen, I don't want to say hundreds, like probably you and Ms. Berrickman have seen these videos, but I've seen quite a few of them. And I've seen some that were not very well done, in my opinion. But I don't know. This could have been the best forensic interview ever, or it could have been full of leading questions, and because I've seen some that were, in my opinion, beyond leading. I don't know what this one is, other than what y'all are telling me.
Your Honor, we've had several of these hearings, and I knew on at least one instance the court did ask to review that before making a ruling, so certainly we can provide a copy of the CPT. In this case, that it has been provided to Ms. Rivers, we can get that to the court.
Any issues with that?
No, Your Honor.
I just think, especially, when was the CPT done?
I want to say it would have been done somewhere around 4/18. It would have been quite a while ago.
This year, though?
No.
Okay. Well, no, because it's a 24 case.
Yeah.
Sorry.
No. So, Your Honor, I will get the court a copy of that.
2023?
Yeah, I'm just looking to see if I have it here. And there was also a medical exam done where there were disclosures. If the court wishes a summary of those disclosures as well, they provide a report. I don't know if the court wishes that as well.
And again, I don't want to use my experience in reading these things or viewing them before, but are there medical findings, or is it just what the child said to the medical provider?
It's statements that the child said.
Right. That's just part of, they've obtained a history, but that would also be additional facts that were provided by the child. I don't know if the court wishes to consider that as additional information that was available to the defense as well. I can provide it.
I think that's one of the things I have to determine, if there's any other way to get the information, right?
Ms. Rivers, any objection to my providing that to the court along with?
Yes, Your Honor, it's just statements. There's nothing more. She provides her statements.
But the CPT is a statement,
Yes.
right? So it's just.
She's already provided her statement in the video.
I think when I look at 92.55 6B5, whether the evidence sought is reasonably available by other means, including whether the victim was subject of a forensic interview related to the sexual offense. So I'm not saying it's going to sway me one way or the other, but I think I have to review it, and just in case it does. How can I say whether or not other evidence is available if I don't get to see the other evidence either?
Okay, Your Honor.
I know the concern sometimes is the court knowing too much about cases, and I think I brought this up at least twice this week already in pretrials, that I'm supposed to stay neutral on all the issues, but if it's an evidentiary issue, I think I have to know what the evidence actually is and review it in order to make a proper decision, especially in a situation like this. Frankly, I understand the intent of 92.55. I think you could probably flesh it out a little bit more as far as explaining and how this should be done. But I think reviewing the actual evidence is I would consider it necessary in order to make such a ruling.
And Your Honor, we will be back before this court on Monday. Would that be acceptable if we deliver it to your office on that day, or would you like it before that?
I mean, we've already moved the case to December, right, yesterday? I mean, I'll look at it as soon as I get it, so I can get y'all a ruling, so you can get it set, if I grant it, set it up. Otherwise, prepare if I say no, you can't do the deposition, at least you know that in advance, and if you want to do anything else about that.
I can have our investigator get it to you tomorrow if you'd rather have it before the weekend. That's entirely up to the court.
I'm trying to think of what I've got going. I've got civil all day tomorrow, I think, so. Monday will be fine.
We'll go ahead and bring it on Monday. I'll show it to Ms. Rivers before I give it to you. Thank you.
Have you seen the CPT?
Yes, Your Honor.
Okay. You mean show it to her, so.
This is what I'm giving him.
So she knows you're not actually giving me something different.
That's right. Good?
All right.
Thank you, Judge.
And I'll just reserve, do you want to make any other arguments short of that, or do you want to come back and make further arguments after I see it, in case I have any questions for you?
We believe that'd be appropriate, Your Honor. in case
Okay.
the
I
court
just want to
has
make sure you've
questions.
had enough chance today, or if you need more, we'll do
In
that
case the
once we
court has
can.
more questions.
Okay. What I'll probably do is, if I get it Monday, if I have a chance to review it before Thursday, are you going to be here, both of you, Thursday? It's a miscellaneous day, I think. Or Friday for jury review. Say again?
We'll be here
I guess we'll
Friday
be
for
here.
sure.
Yeah,
I'm not-
Friday for sure. Your
Friday
Honor.
for sure. Well, then we'll talk about it potentially Friday if I get it in time and can review it. That way, if there's any questions, we can talk about it then. I just don't want to wait around until December 23rd to give you a ruling on it, and then you're kind of in standby mode, I guess, until then.
Just checking the. Definitely do it on the 7th. Is that Friday? That would be good.
Do you have anything set on the
For jury
7th?
trial review? Yes.
Okay.
Fortunately, yes. Both the 6th and the 7th, so.
I mean, I've got my list of the cases that were set, but for some reason I didn't list the prosecutor on them, which
We have a case together set for the 7th.
I usually keep
We have
track of it.
3.
That way I can figure out how many people have how many trials each. But for some reason I didn't write that down last time.
There were numerous ones set.
What do you have set, Ms. Basso?
I saw with Ms. Rivers.
3? I think 3 with Ms. Rivers. Yeah, Plank, Scott,
Thompson
and
is-
Taylor.
Taylor, and then Thompson also with Mr. Hardy, so, yes.
Did you say Thomas?
Thompson.
That's not, I don't have a Thompson.
One of the first ones in the morning.
I'll take a look at it. Maybe I missed it. All right. So we'll see you back on next Friday, and I should have a ruling for you that day unless I have questions or want more argument that day. All right. Thank you.
Oh, okay. That's fine.
Stevie's going to need a hearing aid. Judge, this is going to be Herbert Atkins. Case number for the record is 2007 CF 622. Can you hear me, Mr. Atkins? Charles Russell Public Defender's Office Judges, as I stated, this is Herbert Atkins, case number is 2007 CF 622. If the court will recall, back on October the 9th, we had a competency hearing. The state requested a second eval. The court has signed the order. The order was signed on the 16th. It's for Dr. McDonald. Today's only the 30th. I have not received a report. I'd be surprised if she's even had a chance to see him yet, but I can follow up on that to make sure she's got the paperwork.
And Judge, my office, after the order was signed, did send all of the information, including the prior evaluation and the VOP discovery on the 17th. And she had some problems opening it, but she did confirm on the 24th that she had everything she needed. So
Good.
I guess at this point, we're just looking to pass the case until she's able to give us her report.
Okay. Did you understand that, Mr. Atkins? You couldn't hear? Okay. Ms. Barrickman, who's the prosecutor on the case, she has sent all the paperwork to Dr. McDonald. That's the lady doctor that's going to come see you. And so you haven't seen her yet, have you? No. Okay. She's going to come see you, okay? And so what we're going to do today is get you another court date to give the doctor time to see you and then write her report, okay? And as soon as we get it, I'll come and show you the report as soon as I get it, okay? And if we get it earlier, then we'll get you another court date sooner if we can, okay? Yes, sir.
All right, what date would you want to put it on?
I obviously don't think next week's miscellaneous is going to give
Yeah.
us much traction, so.
Why don't we do this? We'll put it on 12/4, 9 o'clock. But if you get the order, or not the order, the evaluation back, you'll have an agreement on it as far as stipulation. What did the first one come back as?
Incompetent and unrestorable.
Okay. So if y'all want to stipulate to those, I'm not telling you to, but obviously if that ultimately happens, maybe put it on one of those pretrial detention dates and see if we can't resolve it. Although this will be during my criminal trial week, so I'm not sure we're going to have a whole lot of time. But if we can get it in early,
yes,
it'll be a quick hearing, then we can try to move it up.
Yes, sir.
All right. Otherwise, 12/4, 9 o'clock.
Do you hear that? December 4th at 9 o'clock, unless we get the report before then. Okay? That's the next available date.
2 years I've been in that jail.
Okay. We're going to try to speed it up as much as we can, okay? Thank you, Judge.
All right. Thank you.
I have emails lined up from Mr. Williams.
Ms. Davis?
Davis.
I don't believe Ms. Davis.
What's your first name, Miss Davis?
Cheyenne.
Did you hire someone?
Oh, she did, Your Honor. Yes, she did. She's retained private counsel. She had private counsel on her 3 cases. Mine was the one lingering case, and she's since retained private counsel, Your Honor.
Okay, and I think they filed a motion to continue and sent it to my office after 5 o'clock yesterday.
Yes, Your Honor. Well, I can't speak to that, but I would assume you're correct on that.
I saw that, Judge.
I didn't know about it till this morning because I was on the bench until 6 o'clock yesterday, as you all know, because you were here too.
Yes, Your Honor.
Most of you were. Problem is, I can't see the motion now. I know they sent it to my office, but I don't have it.
Did he file a written plea of not guilty in this case, Your Honor? If not, I would do that on her behalf, but that's it.
Okay.
Oh, denial then.
There it is. All right, Ms. Davis, I've read the motion that was filed by Mr. Ramey. I'm going to put you on December 4th at 9 o'clock. You didn't ask for any specific date, so that's my next miscellaneous date. That'll be done without subpoenas, since that wasn't requested.
Yes, Your Honor.
All right, thank you, Ms. Davis.
Ms. Green is listed under Mr. Williams, I believe. She's right here, Ms. Green.
All right, this is my case. This is Miss Gloria Green before the court in 25 CF 1817 and 25 CF 494. Your Honor, I'm going to have her evaluated for competency. It'll be internally, so I'll get that done.
Is this her first court date on the VOP?
It is, Your Honor.
For some reason, the name sounds familiar, like we just talked about it. All right. So what date would you like?
Or, excuse me, no, it's not, Your Honor. 10-9 was her first date on the VOP. It is her first court date, however, on the new law case in 25 CF 1817. Apologies.
Oh, that's for this afternoon?
Yes, Your Honor.
All right.
But we would enter a plea of not guilty on the afternoon case, Your Honor, the new law violation in 25 CF 1817, and a denial on the VOP in 25 CF 494 if we haven't already.
Is there an information filed on the new one?
I believe there is, Your Honor. Let me double check.
There is.
Okay.
Okay.
Was on all the others I looked at.
They got me to come in here twice.
All right, do you want them both in December then, the
Yes.
23rd?
Should have the evaluation back by then.
All right, December 23rd,
All right, thank you, Your Honor.
9 o'clock.
All right.
Sorry, Deputy Williams, did you say Everest? Kegaris, okay, that's mine. Judge, this is Stacy Kegaris, 25 CF 981. Judge, I've been unable to reach an agreement with the state on what she wants. Based on my 2 meetings with her, I'm going to ask for an expert to help me on this.
Okay. All right, what date are you looking for, Mr. Williams? 12/4? Does she have any other cases? I think it was just
Judge, I'm not aware of it. She was placed on
probation and never showed up, according to the affidavit.
and she, in my discussions with her, there's concern that she seems to think that she was never, she's still waiting to be sentenced.
Okay.
And be able to start her probation. And so I want to have that looked into.
Gotcha. You want to do 12/4? Over a month?
Yeah, let's do that. I don't want her waiting any longer than she has to.
All right, ma'am, we'll see you back on December 4th at 9 o'clock.
All right, thank you, Judge.
Thank you.
Ms. Owens, come on out, please, ma'am.
Judge, this is Rebecca Owens. We've got a negotiated plea in this case.
I have attached the score sheet.
Okay, thanks. Ms. Owens, this is the plea agreement I just went over with you.
Yes, sir.
I need to get your signature up here if this is what you want to do. While she's doing that, Judge, this is the lady that's in a program over in Walton County Jail. And so what the agreement's for is 1129 credit for time served, and that would include her time in the program in Walton County Jail. Ma'am, you mind if I date this for you?
No,
The
that's
state's
fine.
agreement.
Yes, Your Honor, it is.
Was she going back to Walton after this?
I believe she still has more of that program to do, Judge.
It
In
doesn't-
fact, I think she's dressed in Walton.
It doesn't end till January.
Okay. All right, Judge, thank you very much.
It says 11 months, 29 days county jail concurrent with the 120-day program, Walton program, and credit for time served. So I just want to make sure, so when she finishes the program in Walton, will she have enough time served for our case?
Judge, I don't know for sure.
Wait.
Are you thinking that when you finish the program in Walton, that you'll
Well-
have also served with the credit you have, the 1129?
As of right now, working on my 6th month in Florida. What about?
Well, 6 months since you were arrested on this Okaloosa
Yes.
case? Okay.
Is that not going to run with that?
It is.
I just want to make sure if it's 1129,
The
that you
program
don't,
doesn't end till January. I've been incarcerated since May 29th here.
I guess I don't understand. You've been in the Okaloosa County Jail since May?
May 29th, yes, sir.
How are you in a program in Walton County?
It's the RSAT program. It's
I don't know anything about it.
the resident, it's a substance abuse treatment program. They came and they did applications for people that wanted to go into this program. It's alcohol and substance abuse, and you would work there. And there was 6 of us, there was like 40 that applied, 6 got interviewed, and 6 got took, but there's only 3 of us there now. You couldn't be sentenced or anything.
My concern is, looks like you had 2 weeks in jail or so before you got out the first time, then 'cause you were put on probation. Then you got booked in again May 29th.
Yes, sir.
So you've been here about 5 months. You go over to Walton and do 120 days. I don't think that's going to get to 1129. So what's going to happen?
Finish it here, wouldn't I?
That's what I'm asking. I think it has to be clear, otherwise.
Right, I'll come back here and finish it, correct?
Yes, ma'am.
Uh,
The way it's written up, yes, ma'am. Is that your intention, Ms. Whalen?
I just,
Finish that program, then come back here?
if she's in jail here, she's going to go to do 120 days in Walton County, then come back and finish her sentence here?
Does that 120 days going to count?
Yes, ma'am, it's going to count. That's not what we're.
Okay.
I mean, this is a jail program. She'll be in the Walton County Jail, right?
Yeah,
Okay.
yes, sir.
Yes, sir. Yes, sir. And it's actually, I said concurrent, that's probably not a good term of art. She's in that program as a result of this arrest and this sentence. It's just that that's where the program is, and so that's where she's being housed.
So she doesn't have Walton County cases?
I don't
No,
think
sir.
so.
So the jail's telling me that if she's released on this case, if her time doesn't get passed, she's not going back to the program. So I don't know.
No, we're not thinking that she's going to be released before she finishes the program, or that she's going to be released today. She doesn't have that much credit.
My question is, since she only has, best I can tell, about 5.5 months credit, and you throw another 120 days on it, so that's basically 3 months, that's 8.5 months.
Yes, sir. Yes, sir.
11:29 now, obviously, she's going to probably get some sort of gain time. But my concern is, even if it's a day, a week, a month that she doesn't finish, what's going to happen?
She's going to be transported back to the Okaloosa County Jail for the remainder of her sentence, is what everybody's understanding is, unless the state wants to provide that it be suspended upon her completion of the Walton County program.
Need to check 1 second, yeah.
I just think it needs to be spelled out in an order, so Okaloosa and Walton County jails know what they're dealing with. Otherwise, it's not going to work. And ma'am, I'm not trying to stop it. I'm just trying to make sure it works right, or you don't end up
Yes,
in a
sir, I
situation
understand.
where someone comes back to you later and like, hey, you never finished your jail sentence.
This is the first time I've seen this program utilized, as she indicated, it's brand new, and I was surprised when they notified me that she had been sent to Walton County.
Is there an automatic like start date? Like, do you have to start on a particular date in this program, or is it just 120 days once you get there?
No, it actually started a week late. I've been over there a month now, 6 weeks, almost.
Wait a minute.
I've been in Walton County for 6 weeks, almost.
So that 120 days has already started then?
Yes. She's been doing it.
So she's definitely not going to have 1129 in.
It ends in January.
Yes, sir, and it was anticipated that she would not, she'd still have some more jail to serve, and she'd be transported back.
Your Honor, the state will be fine in just terminating once she's done with Walton County.
Okay. I'm going to write that onto the plea form and then have you initial it, Ms. Owens.
Yes, sir.
Mr. Williams, if you all could take a look at that, just to make sure you like the language that I had, and then everyone initial it, and then I think we'll be ready to go. It's also a downward departure.
It's on a misdemeanor, Judge.
Oh, it's on a misdemeanor?
Yeah.
The original charge was aggravated battery.
Well, you guys gave me a score sheet, so.
You're right,
Sorry, Judge,
you
force
shouldn't
of
have
that.
the score sheet.
Yeah, because I've got the a paper affidavit of violation as well, so someone just gave me things I didn't need. I'll just have Mr. Williams collect all his stuff later.
Yes, sir. Right here?
Yes, ma'am.
Thank you.
Initial here?
Yeah, just anywhere in there. All right, Judge, everyone's reviewed it.
Okay.
Initialed it.
Can you take the score sheet and
Yes.
that affidavit back? I think that goes back to Mr. Maddox. That's from
That's McPherson. He's actually my case.
Oh, that was your case?
Yes.
All right, Ms. Owens, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Rebecca Diane Owens, and my birthday's January 15th, 1979.
All right, and Ms. Owens, you're here in 24 CF 2603. That's a 0? Okay. For a violation of probation, so, because you've got ag-bat on here, but it was a misdemeanor battery?
What she actually, that was the original charge. What she pled to, looking at the file, was a misdemeanor battery. This was Ms. Rivers' case originally.
Okay. All right, so it was a violation of probation solely on the misdemeanor battery. I've got a plea offer here, an agreement that you've now signed and initialed the new section that I wrote in there, Ms. Owens, that would call for you to admit your violation, be an adjudication of guilt, 11 months, 29 days in county jail concurrent with the Walton County 120-day program that you've already started. Upon successful completion of that 120-day Walton County program, which you said is in January,
Yes, sir.
that this jail sentence would be complete upon completion of that program. And you'll get credit for time served. I'll certainly put that in here, but I'm not sure it's really important now because I've given you an end date. All right, also there should be a $100 VOP fee and a $100 cost of defense.
Yes, sir.
Okay. All right, is that what you want to do, Ms. Owens?
Yes, sir.
All right, did you go over this edited plea agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And that's your initial down here at the bottom where I added that section about successful completion?
Yes, sir.
Okay. And are you satisfied with your lawyer's advice and representation?
Yes, sir, I am.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
And you understand by entering a plea, there won't be of an admission to your VOP, there won't be a hearing where the state would have to prove that you violated your probation.
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation.
Yes, sir.
All right, and what is your plea to the violation of probation? Are you admitting or denying it?
I'm admitted.
All right, I accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, revoke and terminate your probation, sentence you to 11 months, 29 days county jail concurrent with the 120-day Walton County program that you've started and credit for time served, and specifically would like in the judgment, this jail sentence will be complete upon successful completion of the 120-day Walton County program. To be honest, Ms. Owens, I think by the time they figure out your gain time and all that, it would have been very small difference, if any. I just wanted to make sure it wasn't a situation that wasn't done correctly or you'd have to come back to our jail.
Right.
Because I think that's just kind of a waste of resources at that point to transport you back and forth several times.
Yes,
Which
sir.
we've already done, it looks like, at least once. All right. Is it a conviction before?
Judge, actually, my file's not noted whether it was an adjudication or not.
Just for purposes of fingerprints.
Yes, sir.
Yeah, it was a withhold before, so I'm going to need your fingerprints, and you'll have 30 days to appeal. Step over and
Oh.
Okay.
Ms. Watson?
Do you have any questions? I need you to sign it, Dave. Your Honor, Ms. Watley is signing a plea agreement to resolve this right now. At this time, Ms. Watley is going to admit violating supervision. The agreed-upon disposition is that her supervision will be reinstated and modified to extend the term date 2 years. Her original term date was October 23rd. The VOP warrant was issued on September 15th. So the reason why there's going to be an extension is so she can pay off this restitution. She will have to pay a minimum of $333 per month toward restitution. Ms. Watley is just asking if that can start in the month of December. She's been out of work for a month because she's been in custody, so she's going to have to get back to work. She's got a job. She just doesn't have the $300 right now. So are you okay with that starting in December?
I can pay it. I'm her mother. I can pay it.
I just want to make sure that we're not setting her up to fail by imposing something she can't do in the month of November. The supervision will automatically terminate at any point once that restitution is paid. The situation with the restitution, Your Honor, is probation is showing balance in the neighborhood of $27,000 and change. Ms. Watley's family has receipts showing that the balance is really $7,000. That's how we got the $333, is dividing, 2 years by $7,000, or $7,000 by 24. So she has been instructed by me to make a point to get the restitution paperwork to probation immediately when she meets with them. The state would agree to continue her withhold of adjudication. May I approach?
Yes. I'll have a score sheet. Or is it just?
For Mr. Marshall.
I'll print it, Your Honor.
This is
Reinstate
her,
modifies.
right, this is
Oh,
her
okay.
only, this is,
It's a modification
Right,
that-
it's a modification.
Okay,
It's a-
I think we're good then.
She has no prior record.
All right, Ms. Watley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Brittany Diane Watley, February 10th, 1990.
All right, and Ms. Watley, you're here in 22 CF 733 on a violation of probation on a third-degree felony. Do you understand that? Okay, and I've been handed this plea agreement that calls for you to admit that you violated your probation. In return, it'd be a reinstate to that supervision, modified to extend the supervision by a period of 2 years, reimpose all previous conditions. Your probation would be automatically terminated, or it shall terminate. I know that's the language probation likes. At any point, once restitution is paid in full, but you do have to pay a minimum of $333 per month, which will start for December. But obviously, again, the faster it gets paid off, the sooner you're off supervision. $100 cost of prosecution and $150 cost of defense. So that you've got some additional costs that way too. Is that what you want to do here today?
Yes, sir.
All right, did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
Just anxiety and depression.
Okay. Do you know what's going on here today?
Yes, sir, I do.
Okay. Are you being treated for those things?
Not since I've been in jail, but yes,
Okay.
outside.
Do they usually affect your thought process as far as understanding?
It just helps keep me calm and I don't stress as much.
Okay. Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for the plea?
No, sir.
And do you understand that there won't be a VOP evidentiary hearing because you're entering a plea? So the state doesn't have to prove it because you're admitting to it?
Yes, sir.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And what is your plea to the violation of probation? Are you admitting or denying?
I'm admitting, sir.
Okay. I'll accept your admission as freely, voluntarily, knowingly given. Adjudicate you, well,
There's a withhold.
it's staying the withhold.
State's going to keep the withhold.
Okay. Well, I think I keep the withhold or not. Withhold adjudication, reinstate the supervision, modify and extend your supervision 2 years, reimpose all prior conditions. Your probation shall terminate once the restitution's paid in full, but you will have to pay a minimum of $333 a month, and that will begin for the month of December. $100 cost of prosecution, $150 cost of defense.
Yes, sir.
All right, I'm going to have you go talk to probation since they're going to give you some instructions today. You have 30 days to appeal. You know, in some other counties in this circuit, there's no such thing as a plea agreement in the
I know.
DOPs. Because
I learned that
technically,
the hard way
it's.
once. All right, you good? All right. Go ahead and sign and date it. I talked to the program. Your Honor, Mr. Marshall is signing a plea agreement. We're going to withdraw the bond motion. Mr. Marshall has reached an agreement to resolve this case with the state. This is going to be a downward departure situation for Mr. Marshall. He's going to be entering a no contest plea as charged. The agreed-upon disposition is that Mr. Marshall will be sentenced to 2 years of probation. Special condition of that supervision is that he will successfully complete the Chrome treatment program. That is a program in Marianna, Florida. I have talked to the program multiple times over the past 2 days. They do have a bed available. Mr. Marshall will transport himself over there. He has to be in this program by 5 PM tomorrow afternoon. So he is aware that the responsibility is on him to transport himself, get himself over to Mariana to get into the program. He's got to be there by 5 o'clock tomorrow afternoon. He will have no contact with the victim in this case, and I had that pulled up here a minute ago. He's previously been adjudicated. He would be assessed $615 in court costs and $150 costs of defense. May I approach? I'll get the name of that victim for you.
And what's the basis of the downward departure
It's the need for treatment.
for treatment?
The name of that victim, Your Honor, is Daniel Young.
Daniel Young?
Daniel Young, yes, sir.
All right, Mr. Marshall, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Marshall, you're here in 25 CF 1667. You're charged with grand theft auto, which is a third-degree felony, which is punished by up to 5 years in state prison. Do you understand that? Okay. Have you gone over this plea and sentencing agreement with your lawyer? Is that what you want to do today? Did you understand it? And is that your signature on the back there? All right. Are you satisfied with your lawyer's advice?
Yes, sir.
And you heard him announce the terms of your plea agreement, so you understand those. So I'm not going to read them again until you actually take a plea, so I can save myself from doing it twice. All right. Are you under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
Sir.
Anyone force, promise, or force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for the plea? You understand by entering a plea, there won't be a trial of any kind, and you're waiving your trial rights, which are listed on page 1 and page 2 of the agreement that you've signed. And do you understand that you're waiving all potential defenses? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, and it's an adjudication of guilt, so that's a felony conviction. You understand that? All right. And what is your plea to the grand theft auto?
It's no contest.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 2 years probation. You must successfully complete the Chrome treatment program over in Mariana, Florida. You're going to report to the program no later than 5 p.m. tomorrow, October 31st, 2025. No contact with the victim, Daniel Young. $615 court costs, $150 cost of defense. Waive cost of supervision due to the fact that you'll be in the treatment program and you've been found to be indigent. Just make sure you get there by 5 o'clock, Mr. Marshall. I'll just throw in here, I become the duty judge at 5 o'clock tomorrow as well. So if it doesn't happen, I'll be the one on duty this weekend to deal with it.
Yes, sir.
So make sure you get there. All right. This is a downward departure based on your need for treatment because you scored 25.2 months. Do you understand that? So this program is very important because it's everyone that's involved in the case thinks it's better for you to get the treatment that you need as opposed to serving this prison sentence. However, if you don't successfully complete the program, you're going to be back here and potentially talking about a prison sentence. And I think we had somebody on the docket this morning who didn't successfully complete the Chrome program and is back looking at potentially prison time. So just make sure you take it seriously, Mr. Marshall, and I wish you the best of luck.
How many months is it again?
It's a 20-foot, well, it actually would even be more than what's on the score sheet, because if there's a violation, you're going to add violation points to it, so.
25.2 months, it depends. If it's
That's-
just a technical violation, that would add 6 points. So that would still be, probably somewhere between 25 and 30 months or so,
Right,
30
so-
months.
I was about to tell you, since the judge went ahead, I'll go ahead and tell you on the record, please succeed.
Yes, sir.
Nobody wants to send you to prison, but if you don't succeed, that's probably what's going to happen.
Yes, sir.
Okay? All right. Best of luck, all right? All right.
I need you to talk to probation first, and then get your fingerprints done after that, Mr. Marshall, and then you have 30 days to appeal. All right. Is that all you have, Mr. Kleins?
It is, but I've got two on 130 docket, so I'm just going to.
Just for everyone who's here, apparently the Supreme Court has amended Rule of Procedure 3.190 as of yesterday. Just y'all take a look at it. Talks about timing of motions to dismiss, including stand your ground, and some other interesting things. I'm reading about a paragraph at a time in between cases, so.
Sorry, Judge, I've just been handed something that.
What's for me right now?
Not one that.
Mr. Kleins, do you have a
indicated
Mr.
what
Klein
you
on your
wanna check, what
docket?
they were offering
Christopher
right
Klein?
now. Is this-
I don't have him on my docket, but I know he's one.
It's not on the docket, but is he here?
If we offer that right now?
Yeah,
Okay.
I'll ask him.
What's the case number on that?
Judge, can
1153. Okay, go ahead, Mr.
That's a
Williams.
second chance. That's an extra year.
Right. Judge, can we recall Mr. Hamilton later today? He's just handed me a counteroffer he wants me to present to the state.
Want to bring him back this afternoon, then?
Judge, we'll probably have an answer shortly.
Well, I understand it's 11:43. We have pretrial detentions at 12:30.
That's fine then, Judge.
I'm on the end of the 1:30 docket.
Okay, that's fine.
I mean, I'm just sometime this afternoon, once we get to it.
I haven't been checking the clock, so. All right, so we'll bring it back at 1:30, and we'll have an answer one way or the other then.
Can you mail this for me? I don't trust the jail.
I don't know.
Okay. Just hang on
Okay.
for me then. Thank you.
Judge, this is Mr. Hinesley. It's case number 23 CF 2649. The case was set for sentencing. It wound up set on the morning. It's going to be more extensive than that. We talked about it or advised the court yesterday that we were likely to ask for more time. I've decided to get a mitigation evaluation done. And during that time period, I'm going to continue some research on another issue.
When would you like to set it? I just know we've got that other case where
Yes, sir.
mitigation evaluation report has taken quite some time and
Yes, sir. Yes, sir.
led to us continuing the case 3 times.
He is desirous to get it done quickly. I did speak with him, and we can use Dr. McDonald on it. I don't know if she's less backed up than Dr. Zeman. Judge, give me at least a month out.
I can do December 4th, or after that, it's going to be January.
So you want me to try to rush this for December 4th? Judge, let's go ahead and set it then for December 4th, and
You want to put it in the afternoon if you think it's going to be
in the
more
afternoon,
extensive?
Judge.
Please, Your Honor,
Okay.
yes.
December 4th at 2 p.m.
All right, thank you, Judge.
All right, thank you. For sentencing, yes.
Michael, okay. Judge, we have a negotiated plea on this.
Who is this? I'm sorry.
This is Michael Johnson. It's case number 19 CF 2000. He's going to be going into the Master's Touch program with a reinstate to the original terms and conditions.
Sorry, what program?
Master's Touch.
What is that?
I'm not sure where it is, but it's
I've just never heard of it. What is it?
It is a program, he's going into it because there's a bed available, but it also deals with people with history of sexually based charges.
Your Honor, may I your coach?
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Oh, not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida.
All right, Mr. Johnson, we're just going to wait for you to get the response from the program about you, how you're going to get over there. So we'll just going to pass you to this afternoon.
Yeah, we're going to do it today.
So it's going to be today. It's just going to be waiting on that response.
Thank you, Judge.
All right. We'll see you in a little bit. Oops.
Mr. Kemp? Okay.
This is Kemp.
Yes, sir. Judge, actually, I was appointed representing him, at least that's what my record's showing. Okay. Judge, it doesn't look like we're going to be able to resolve it with a plea today. The state and I are at loggerheads. You The defendants advised me that he may have some records that will substantiate what he's saying happened, so I'm going to ask to continue it. He's asked me to request about 60 days on it, so I'm going to say not December 4th.
January 8th?
Do you think you can get all that by January 8th?
Yes.
Okay.
Your Honor,
Sir?
what had happened, the guy gave me.
Hold on a second. Are you about to talk about the basis for your violation? Anything that you say is going to be used against you.
I'm telling the truth. I got no problem.
Well, you got the prosecutor sitting here, right? Everything that's said in this room is recorded. And so
That's
if you say anything that can be used against you, and then in 2 months when y'all come back, you decide that you have to have an evidentiary hearing, they're just going to play the tape from what you just said, or what you're about to say. I've warned you.
Yes, sir. I wanted to see if they get the GPS coordinates out of the van. I'm not lying. They told me to secure a place to go to when they EOS'd me out of the hospital. They told me to get a place to go to in Crestview. I said, well, what are you doing? You're not letting me back into the Phoenix house? They said, no, we're putting you on this van and we're taking you to Crestview. I had no prior knowledge of it.
It's hard to understand this if you don't know a bit of the backstory.
I just want to make sure you understand, I'm specifically not asking the questions because
I know,
I don't
Judge,
want
and
to ask him a question that's going to incriminate himself in some way. So that's why I'm not asking any follow-up, Mr. Williams.
I'm just telling the truth, sir.
I understand that, but he doesn't know about the phlebitis, he doesn't know about the blood clot, he doesn't know that you were in the hospital, he doesn't know anything yet. So
Yes, sir.
what my suggestion is let's get the evidence that we need, and then if we have to have a contested hearing, or if you decide to do a straight-up plea as a plea with an explanation, we'll present all that to him in a logical format at that time.
Yes,
Right
sir.
now, he's kind of being given stuff out of context.
I just want to explain to you, Mr. Kemp, even if we have some hearing where I have to make a decision on these things, and it's not till January, no offense, there's no way I'm going to remember what you tell me right now. I'm going to deal with literally hundreds, if not thousands of people before that date, between now and then. So it's hard to, that's why I do so much going back and rereading and rewatching things that happen in court, because it's just hard to retain all that on the 1,600 plus cases that I have.
I'm my bad. I'm
Oh,
sorry.
it's okay. I'm just trying to explain it to you. It's not that I don't care. It's not that I don't want to hear your story when it's time for you to tell it to me. I just don't think I'll remember it at that point, and I don't want you to do something that's going to harm your case.
If, you will consider sending me back to
I'll consider it
rehab?
whatever we talk about when we get to that point.
We're not there yet.
I'm not locking myself into something when I don't know what the details of it are.
Okay.
All right, so it's going to be January 8th, 2026 at 9 o'clock.
Thank you, Judge. All right. Either myself or perhaps my investigator will come out and get some more information from you.
Yes, sir.
So that we can get everything in, okay?
Thank you.
All right.
Why are they listed at 12:15?
Judge, this is Mr. Koiser. Again, we're at Loggerheads.
I just had to look that up, Mr. Williams. I had no idea. I've never heard that term before.
Sorry, Judge.
Yeah.
We're butting heads on it. Mr.
Loggerheads fight like that or something?
I don't even know what a loggerhead is. I guess it's a turtle.
It's a turtle. It's a sea turtle, right?
But we're,
I'm sorry, I distracted you.
that's all right. We're seeking probation's recommendation, which is based on the fact that he had been on supervision for so long without any problems. And then there was this one incident. The state's wanting a guideline sentence, which in his case is going to be in the neighborhood of 60 months. He had asked, or we had talked about my talking with probation. I don't think the probation officer here was individually involved at all in his case, so you wouldn't be able to provide any information. So although my understanding is his mom drove up here, do you see her?
She's
Okay.
not here, she's waiting.
All right, it may be that that my assistant got a hold of her in time. I don't know. But he was wanting to get it resolved today. Guess the only thing I suggest is maybe we could put him on this afternoon as well. And I'll try to call the individual probation officer and ask her to contact the state attorney.
Let me just make sure I understand. So probation's recommending one thing, state attorney doesn't agree with that and wants a guideline sentence.
Yes, sir.
So what is there to really deal with other than he either takes their plea offer, or you plead straight up, or you set it for a hearing?
What we're hoping, or what I think he's hoping, is that if Ms. Leone talks to the probation officer that made that recommendation, she can better understand the nature of the recommendation and will perhaps change her mind.
Yeah, the problem is that the probation officer doesn't know the reason why I agreed to that plea to begin with. He was charged with trafficking in methamphetamine over 14 grams. I believe not, it was over 56 grams. It was an easy case for the state to prove because he was caught while in DOC with those drugs on him after a search. The case was tried, I tried to set the case for trial numerous times, and Ms. Gooden kept delaying everything. At the end,
That his previous defense counsel.
previous defense counsel, yes, Your Honor. I just allowed, based on the prayers made by the other counsel, I agreed to allow him on probation as the very last chance, just to give him a chance. And this is the reason why now I'm asking for guidelines. He was facing 7-year minimum mandatory.
I'm looking at the plea and sentencing agreement. Is there a suspended sentence?
Judge, I don't know. I don't have,
And that's
we
from
weren't
May of
involved in the plea.
24, so it's before my time.
I don't remember, I apologize about that, Your Honor.
Oh, you're fine. I'm looking at the plea and sentencing agreement from May 6th of 24. There's 11 months, 29 days county jail, followed by 2 years community control with 6-year suspended sentence
Yeah.
can transfer probation to South Florida.
Yeah, okay, Your Honor, yes.
I'm just asking.
No, you're right,
So
you're
if you're asking
correct.
for 60 months, but he's got a 72-month suspended sentence.
If he pled, I'd be okay with the guidelines.
Judge, he's asking me if it would be okay for him to speak. I think he wants to respond to the state attorney's allegations.
I'm not asking you any questions, Mr. How do I say your last name?
Cozier.
Cozier?
Yes, sir.
Okay. I'm not asking you any questions about it, but if you want to talk, I'm not going to stop you. But just remember, the prosecutor's sitting right here,
Yeah,
and everything in this room is recorded and can be used against you.
I understand, sir.
But I just give the warning to anytime someone wants to tell me something like this.
I'm just simply stating that Ms. Gooden had fought for me on that charge because I was being put down by gang members in prison, and the drugs were found inside my anal cavity, and I was seeing mental health aspects for this. I've had ongoing health problems from this. It wasn't something that was even a choice matter. I was just trying to go home, and I did everything according to my compliance. I've been paying all my fines. I had a job. I'm working. I'm taking care of a senior mom. I'm doing everything I'm supposed to. Technical, I understand, and I have no problem accepting that. I would even be willing to do the ankle monitor.
Judge, I think again, the rationale for probation's recommendation was that he had been a good probationer up until that point, or community controlee. I don't recall off the top of my head. I have to look at the file, but they'd not had any problems with him, and they apparently felt that this was a hiccup and more deserving of additional community service work. And I've seen that happen before.
If I may, I disagree with that. I'm reading off of the report from the officer. This officer who violated Mr. Coiter said that the officer would like an opportunity to personally gauge the offender's pattern of behavior before recommending stricter conditions. So I'm not I don't quite agree with Mr. Williams' interpretation of the probation recommendation.
Well, Judge, give me just a second. Let me grab the probation record.
And I'll be fine, if we want to set it for a contested hearing, we can do that.
I'm looking at the violation report filed 8/8/25. It reads, recommendation, Department of Corrections requesting a warrant. This offender was recently gained by Officer Sims, and previous case notes do not document this offender having had issues previously with following his approved weekly schedule. The officer recommends that the offender's community control sentence be modified to include 150 public service hours, and Thinking for a Change, which is a program that they have, it's like a class or a video that they watch. If the time comes where the offender is found to be abusing the freedom allowed by community control, this officer, will recommend community control too. This officer would like an opportunity to personally gauge the offender's pattern of behavior before recommending stricter conditions. So taken in context with the rest of the statement, I think it paints a somewhat different picture.
What I've gathered is y'all don't have an agreement.
Yes, sir.
Right.
I'm not one to negotiate these things. I think I've said that numerous times this week. I mean, if it's a situation where, someone enters a plea, I'll certainly, and it's to the court, I'll make a decision. But I don't like to get in, until I know everything, I don't like to make it sound like I'm leaning one way or another, or even somewhat being given plea offers from the bench. I don't think that's not the way I do things.
And Judge, I was just trying to respond to the statement that she
I
made
understand,
and
but
put it in context.
We're here for a court date where we have a few options. Take a plea offer, plead straight to the court, continue it, or set it for a hearing, but evidentiary hearing.
I was originally trying to get the officer and Ms. Leone together where they could talk. It doesn't sound to me like that's going to be fruitful, at least not today. So with apologies to Mr. Kozier,
Are you talking about the community control officer from South Florida?
Yes, sir, by phone. With apologies to Mr. Kozier, my recommendation is going to be that we continue the case and continue to try that, or that we set it for a hearing where the judge would then make a decision. In the interim, I'll talk with you again about how straight-up pleas work. And I'll advise you the one area where I think that sometimes can benefit. Generally, that's not what I recommend, but in this case, it may be. So given that, do you want to go ahead and make a decision today to accept a guideline sentence on it, which is going to be almost 5 years, or do you want me to continue the case out, or willing to allow me to continue the case out, or do you want to enter a straight-up plea, or do you want to go ahead and let's set it for a hearing, and then if you decide to plea after that, you can always change your plea at or before the date of the hearing.
I'm not fully understanding.
Judge, let's go ahead and pass him then to come back this afternoon.
Can I just ask real quick?
Yes, sir.
What did he plead to? Trafficking more than 14 grams
He did.
of,
Methamphetamine.
oh, how was it 11 months, 29 days county jail?
I don't have the plea agreement, Everything happened by agreement, of course. That's the first answer I can say, and it was Judge Gontarek accepting the plea at the time.
I mean, am I wrong that it's a 3-year minimum mandatory?
No, you're not wrong.
There is a procedure whereby the state can elect not to seek the 3-year mandatory minimum. But I was not opine on it, just that there's one where they can not seek it.
Exactly. That's exactly what I'm trying to represent to the court, that it was a good agreement based on the evidence that we had.
My concern is suspended sentences typically don't get rid of minimum mandatories, and I think there's an appellate decision that basically came out of this division in the past few months about that. So, or my time. DUI manslaughter case, I think. Just adding the wrinkle into it. I mean, one of the reasons I don't do suspended sentences for the most part, I just don't think they're worthwhile. I don't have to give them to somebody, and I can do less.
Yes, sir.
And it actually is a limit on the upper limit. So it's just it takes away. It's courts giving away their own discretion, which is not something I normally want to do, because I want to make it a decision on what the case is and what it isn't, as opposed to limiting myself one way or the other until I get to that point. Frankly, I may have to go back and listen to this plea colloquy and what went through it, because I don't know how it went down.
Yes, sir.
All right, but again, it doesn't sound like we have an agreement today, so what do we want to set it for? What's that?
All right.
All right. We can do that.
Okay.
Well, I think it's just because Mr. Kleins, while they're trying to figure out what they're going to do here, were you advised about McTier? I had appointed RCC yesterday, and again, it was just a situation where the case.
I saw my name on the transport list, but then I looked on the clerk's website.
I mean, I just, there's not even a written appointment. It was just something that happened late yesterday.
Okay.
But it sounds like he's got some sort of dental issues, so they want to get him out of here. I'm not sure if you, I just brought him in case you wanted to talk to him.
Oh, yeah, I'll go.
Since you're here and,
Yeah, okay, yeah. Okay, yeah, I'll just go pop in real quick and tell him.
all right, but I knew there was two of them. I couldn't remember what the other one was off the top of my head.
Morris, Tyshawn Morris.
Tyshawn Morris? Well, that one.
That had happened
he-
some
he-
time ago.
I think he had already been appointed to that one,
Yes.
just a
That
couple of
was,
days.
you're on Mr. Williams.
Oh, Charles Williams.
Remember, yeah,
Okay, and Mr. Williams is not here today.
he's not here today.
So we don't need Mr. Morris. But we just need to tell him that we'll see him on Monday.
It's right here, I'll tell him.
If he's right there, you want me to just pop in? Yeah, I'm good with it. Let me just grab the card.
Well, that's Mr. Williams' other case, but we'll address it. But we got to get moving with this case,
Judge,
Mr. Williams. What are we doing?
Yes, sir. I talked with him, and I'm going to ask to move the case without subpoenas to 12-4.
I mean, I'm not trying to be difficult, but if there's no agreement and we're not here for an evidentiary hearing, then we've got to decide what we're going to do.
I agree, Judge.
All right, so what day do you want? 12/4?
12-4.
12/4 at 2 o'clock with subpoenas?
Judge, I think that may be best. If we can work it out, we'll work it out. But otherwise, that if nothing else, should have the officer present some way by Zoom or phone or physically here, so that we can address that issue.
I don't have an issue with a probation officer from Largo appearing by Zoom.
Thank you. I will send a subpoena.
I mean,
It's at 2 p.m.
2 p.m., yeah. It's evidentiary, so. Or, I think Mr. Williams is back on Monday, right? We talked about this yesterday. Just double check real quick. No, he's not.
All right, so, Mr. Poyser, right now, it's set for an evidentiary hearing so that we can go ahead and proceed and get a ruling whatever way if we need to. In the meantime, that officer's going to be subpoenaed. She's going to appear by Zoom, okay, so she'll show up on the computer screen. And I will attempt to contact her. I cannot force her to talk with me, but I will try to get her to and see if we can figure out what's going on. The state, I'm sure, will contact her as well because it'll be part of their trial prep. Okay?
We set Morris for a date, another date other than today? Yesterday? You're welcome.
Judge Oberliesen, may I be excused?
Yes.
Thank you.
Yeah, no, this is Mr. McTier. I met with him. I know he's having some dental issues. He needs to get back to the jail. I would ask, if it hasn't already, to continue this case to the 12/23 docket, and I'll go up to the jail and talk with him.
I just wanted you to get a chance to meet Mr. Klein since I knew he was going to be here and you were wanting to go with your case. He's going to come out and talk to you as soon as he can. Hope everything goes well with your tooth.
All right.
Thank you.
All right, have a good day.
We have?
This is mine here. Judge, this is Martin McDonald. He's here for a bond hearing. Right, this is.
Specifically for said no, the defense counsel was right. This sentence is not.
What do we have, Mr. Williams?
It's a bond hearing, Judge. This is
Or-
Martin McDonald.
Martin McDonald. Okay.
He was in
25
court
CF
yesterday.
1732. I think we had about 200 people yesterday, so I don't remember everybody's name. Yeah, we had 4 different McDonald's yesterday. McDonald's in Crescent. I was making fun about the restaurant.
Sorry, Judge, I'm finding the motion.
At this point, we're at our next docket, about to start.
Yes, sir. Yes, sir.
I'm always willing to work through. I don't take a long lunch, but I can't force everyone else to do that too. And we're getting to the point where these dockets need to go faster.
Yes, sir. All right, so Judge, I'd filed a motion for bond reduction on him. He's been incarcerated since August 10th. He's got a bond of $2,500 cash professional. He's not able to make that bond. He's requesting to be allowed to sign his own bond. He is currently unemployed, but he supports himself by doing odd jobs and has done so for the last couple of years. He resides at Helping Hands in Crestview, Florida, and he's lived in this area for 35 to 40 years.
All right, State.
Yeah, we discussed this. My score sheet indicates that he scores 114 points, just the prior record.
He scores 114 points on prior record.
Yes, I believe he's claiming that not all of his prior record is correct, and I don't know which charge is disputing, even for me to verify.
At this point, we don't have a score sheet provided to us by the state, so
here it is.
I can't show it to him and have him specify it. And I don't know that right now, before the court's going to give him sufficient time and
I
reflection.
can't see it, but if there's an armed burglary too on there, I don't have any kind of armed burglaries or anything like that.
And
I don't even
those-
score out for prison, I don't believe.
And those are both 19 points. So,
Obviously, they got the wrong name on the wrong face, on the wrong case.
I don't think he disputes the score sheet. We know of at least those two that he disputes. He has had the score sheet in front of him for, I'm going to say, 45 seconds. So I don't think we've got that he's in a position to address all the concerns. I do see that there's a supplemental page with some 45 points on it.
Date of birth, Mr. McDonald.
January 20th, 1974.
And it looks like those include 2 burglary of a structure, and then a large number, but 6.8 points worth of various misdemeanors. And
I'm looking them up just on the DOC website.
yes, sir.
Sale, manufacture, delivery of methamphetamine, possession or distribution of chemicals. 1, 2, 3, 4, 5 burglaries, criminal mischief, grand theft motor vehicle. These are just the cases for which he served prison.
Yes, sir.
Serena, what's the current bond?
$2,500 cash or professional, according to the motion. He's got misdemeanors and felonies all over the place as far as trespassing, thefts. I mean, and that's what we're here for. Yeah, I mean, it's not like he's sitting here on no bond.
Yes, sir. Yes, sir. I
And
understand
the
that.
allegation is that the probable cause has been found that he was stealing alcohol from Walmart.
Yes, sir.
So what else would you like to argue?
Judge, he's just, again, disputed some of the things on his score sheet, but I don't have any more formal argument I'm going to make on the question of bond. We're just asking that he be allowed to sign the $2,500 bond so that he can get out.
I'm just looking at his jail information. He's been arrested 25 times in Okaloosa County. I think $2,500 cash or professional is sufficient on a felony case where he's got numerous priors this year.
Yes, Your Honor.
Motion's denied.
Yes, sir. Okay. All right.
I'm just trying to find if we gave him a date, but I don't think we have it marked down. You know, it's probably on my docket from yesterday.
Judge, it was in court yesterday. I don't recall if we set a date yesterday or today. We still don't have discovery on it, so.
By Sean Morris? Or are you talking about Mr.
No,
McDonald
on
still? Oh, okay.
Mr. McDonald. I'm sorry. I thought that's who we were still talking about.
Oh, no, go ahead.
Have we already continued that? No, we don't. We don't. That comes
If not, I
with-
mean, we can put it for December 23rd. If you all resolve it ahead of time, you can bring it in. But
He's asked about a plea agreement. Do you have a plea agreement?
I can offer a lesser
as far
included
as Morris,
regular
we're just gonna put it on
theft,
December 23rd,
6 months
and Williams will have to go out
jail.
and see him. I just don't have him here. He was
First degree
supposed to be
misdemeanor.
here and he didn't show up.
All right,
Charles Williams.
so it'd be 6 months jail. You get credit for the time that you have served.
Yes.
If
But
you
he'll
want
come
to
out
do
and see
that,
him.
I'll pass you till later this afternoon and I'll write it up.
Probation?
Brought him here 'cause
No,
Charles
just 6
Williams.
months county jail.
And when is the next
Oh, wait.
court date?
The next court
They did
date
say
would be
Monday,
December
right?
23rd.
Okay, hold- Steve, apparently he said he's going to be here Monday, Williams, so we'll bring back Morris on Monday for it. It's all running together at this point.
The next court date was like the 3rd, but
Well, I could put you on the 3rd for plea or continuance, all right? But there's not a lot of point in that unless you know that you want to take the plea agreement or at least seriously considering the plea agreement. And you're not going to, even under the plea agreement, I doubt that you'd be getting out before December anyway, although I haven't looked at it. How much? I tell you what, Judge, let's put him on for Monday and plea or continuance, and I'll draft up the plea agreement. I'll talk with him some more, see if he wants to do that. It's for adjudication, 6 months county jail on a first-degree misdemeanor petty theft. So a petty theft over 100.
That's the plea offer?
That's what I'm offering.
Okay.
I think
All
the
right, put it on
merchandise
Monday,
will-
11/3, 9 o'clock.
All right.
I mean, we spent 30 minutes on the last two cases.
Yes, sir. I'll come out and see you.
Yes, Your Honor. Mr. Everett Booth before the court in 23 CF 2118. Winter denial at this time, Your Honor. Continue it to 12/4 without subs, please.
December 4th, 9 o'clock.
I'll come see you. All
Without
right, sir.
subpoenas. Thank you, Mr. Booth.
Still holding.
Smith. It is. William Talbot, we have to put on Monday because that's Charles Williams' case and he had some personal thing that popped up. So that Talbot will be Monday. I think from what they told me, that's just kind of, there's an issue with his judgment we have to fix. It's not urgent. For Talbot. That's the extent of what they told me yesterday. So. He's not even. Seeing him on this docket, I see him here, but so Cotton was probably just his attorney on the underline, and he just was never taken off. Is she going to be back?
David Smith. Mr. Gilbert's here for Thibodeau. Kevin Embry went south. Is Gavani.
Thibodeau, Ash, and Booker?
Yes, sir.
Are you going forward on pretrial detentions on any of them?
No, Your Honor.
Okay. Lunch, what are you talking
I would say because Mr. Gilbert is here.
Yeah, that's fine, we can do that.
To
I'm
handle
just-
that one.
I didn't expect this docket to go to 12:30. We get
Yeah, he
Thibodeau.
called my office. I'll agree to bond, whatever.
Okay.
Yeah. They're gonna call him. Call him.
We're rolling right into pretrial detention docket, Your Honor.
Yes, sir.
Understood.
I'll wait, Judge, no problem.
No, it's okay. Would you have? No, you don't have that because. But Steve said he's not here.
Okay.
All right.
Okay.
So we are going forward on this.
Sorry, Your Honor, I didn't mean to bother the state there.
Oh, I don't think we were waiting on. Mr. Thibodeau just got up.
All right, understood.
All right, so this is Randall Thibodeau. And it's going to be 25 CF 2039.
Yes, Your Honor, I do believe we may be listed as counsel of record currently. If we're not, or if we are, excuse me, then I would move to withdraw. He has retained private counsel, Your Honor.
We're in the process of filing, but struggling.
And I'll certainly get that order to the court.
So he's here charged with, at least according to the arrest report, when I say charged, aggravated assault, deadly weapon, battery, using a firearm while under the influence of alcohol, improper exhibition of a firearm, and firing a weapon, 2 counts in public or residential property. State's not pursuing pretrial detention?
No, but there are two victims involved. One should be the defendant's wife, and the other one an acquaintance or friend. They both have communicated with my office. I take it back. I don't believe the defendant's wife has communicated with my office, but through Mr. Gilbert, she has indicated that she needs the defendant to go home because of their 3 children. The other victim, the friend, has communicated with my office saying that he does not mind for the defendant to have a bond. Obviously, I would ask for no violent contact with either victims, no firearms or weapons of any sort. And whatever the court decides as far as the monetary requirement, I would ask for a cash or professional.
Prior history?
I haven't had a chance to review that part. Your Honor, I learned about this case yesterday, actually, through Mr. Gilbert. He emailed me. So
He does, Your Honor. He had a DUI and he's had a resisting in the past. Recent past.
DUI is from last year? All right, Mr. Gilbert, your argument? Is it just a bond hearing at this point? They're not seeking pretrial detention?
Yes, Your Honor. Mr. Thibodeau is a 100% disabled Army combat veteran with a PTSD diagnosis. He has a good job and bosses who still believe in him. His fiancée is actually here. She's a nurse. They live together, and they have 3 premature babies that are in Pensacola currently, and she's been staying in the Ronald McDonald House, and is going to be bringing them home.
That's 3?
Triplets, preemies, and so there's the start coming home this weekend. It could take a while to get all 3 in. Like I said, she is here in court and does seek full contact. We've already removed all the guns from the home, and he understands that's going to be for the duration of the case. We have no objection to a restriction on alcohol, or even a GPS restriction at home if that's what the court needs. As long as he can work and take care of any medical needs of his newborns, that'd be good.
And I would ask, Your Honor, because of the prior DUI, and it appears that this incident was also caused while the defendant was under the influence of alcohol, maybe a scrum monitor to be applied on him for the safety of even his own family.
Honestly, from what I've seen, I haven't seen anything that would make me think he's a flight risk. So I think the scram monitor is probably a better thing than a GPS monitor at this point. All right, anything else you want to argue? Okay.
Another thing, Your Honor, I don't know if he was ever even evaluated for the mental health pretrial program.
Can the attorneys approach real quick?
Properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Right. As far as the aggravated assault, I'm going to make that a $10,000 cash or professional bond. It's, and then the using a firearm under the influence of alcohol will be a $2,500 cash or professional bond, as well as the improper exhibition. The other three cases, or those three counts, will be an ROR. Pretrial services reporting once per week by phone. I'm going to do the scram monitor. I'm not sure if there's a price I have to put on that. If it's $1 a day, I'll do it, because I'm not sure how much charges, because that's through, I think, Court Alternatives. It's not something that we do from pretrial. I believe it goes through a different provider. But my concern is the alcohol issue between the DUI and alcohol allegations in this case. So in addition, no alcohol, no drugs, no controlled substances without a proper prescription, and using prescription medicines only as prescribed. No use or possession of any firearms. It's my understanding from what your attorney has told us that they've been taken away already, but don't possess or use any firearms for any reason while this case is pending. No violent contact with the alleged victims. Did the friend want contact? I think Ms. Leone said that they didn't have an issue with him getting bond.
I think that no violent contact.
All right, no violent contact, which means you can have contact, Mr. Thibodeau, but you can't be violent towards them, which is kind of self-explanatory, I guess. Anything else?
No, Your Honor.
Okay. That'll be it. So I think it was a total of $15,000 cash and professional. I'll just put this on the record because sometimes it's not clear on some of these bond issues. I didn't see the amount of bond money is a reason, is the way that they make people with concerns about flight risk make sure they show up for court. The conditions, no guns, no alcohol, no violent contact, that's the dangerous issue. The reason I would have given a larger bond had I not been given the information that I was given, including that the victims were okay with him being released, that he's trying to make money for his not new family, but new babies. So I've taken that into account. I don't want to be a situation where I'm taking money out of a family with 3 young premature babies and putting it into the court system or a bondsman. And just I don't see the reason for it at this point. But Mr. Thibodeau, these are very serious allegations, and I think it's time to make some life changes.
Thank you, Your Honor.
Thank you. Booker?
Yes, Your Honor.
Yeah, that's case number for Booker. I'm just gonna dismiss it.
Your Honor, this is Mr. Booker before the court in 25 CF 2038 for this pretrial detention hearing. Your Honor, I do believe the state has an announcement on the case.
Yeah, I believe a case has been assigned, case number has been assigned. The state is gonna dismiss the case against Mr. Booker.
Okay. And just to make sure it's clear on the record too, this is, Mr. Booker came in yesterday for his pretrial, where that case was dismissed because the state announced that I guess the alleged victim had admitted that she lied about the whole thing.
That's what she said.
And this is related to it. And he was picked up on this new warrant yesterday while in court, and the state's now dismissing that case for the same reason.
Yes.
All right, so you'll be released, Mr. Booker.
All right. Thank you, Your Honor.
Can you back some what is
That on the back end, but it will show as dismissed on anyone who's looking for it. It's going to get flagged in a background check, so
You don't have a case number for that one, right?
I don't advise on
think you have
expungement.
it.
Mr. Williams, you got
Oh,
I don't advise
basically,
on
you go to the
this, so.
clerk's office, they have a packet they'll give you. Read the instructions, it's not that hard. I used to do it in private practice, charge for it, I stopped because it's not that hard.
All right, thank you, sir.
And, Your If I may just quickly, not for you, sir, you're good. Mr. Gabani, was he transported, not transported?
He was brought south.
Okay, he was brought south. Okay, so Your Honor, that case is going to be handled in the south end, I guess?
I think that one and Embry.
Okay, Mr. Embry is my case personally, Your Honor. That one's being handled today as well in the south end, pretrial detention
In
hearing.
the south end.
Okay. All right, well, I'll
Might
figure
just
that
be
one out.
continued to back here next week, but
Okay.
that was the discussion we had, I think, pretty late yesterday about, it's ultimately going to be my case, I should be the one that handles it, but
That's fine, Your
we
Honor.
have to go through the machinations of getting it here.
No, that's okay. That's all right. It's not going to change anything. Okay.
Steve, can you see if they can hold on to Thibodeau real quick? We're supposed to, at 1 o'clock, have his RPO hearing. And it's just that, confirmation that his firearms have been turned over. It's not the full hearing, it's the 3-day hearing.
I don't know
Contact,
what,
obviously.
I'm just gonna do it in here so he can be present for it.
and that's fine. Reasonable caution professional.
Yeah, something.
Did we get a recommendation from mental health?
Sorry, what was that?
Did you verify if we have the recommendation from the mental health?
No, I don't have any. Is there paperwork in the system at
I
this
think
point,
I've
Your
got
Honor?
it upstairs, I think they brought it to me.
Okay, I have not had the chance to review that, Your Honor.
Why don't we do this? Let me go grab that paperwork and we'll readdress her in the afternoon.
I think that would be
That's fine.
appropriate.
And I think it's one of those things, I meant to get to it yesterday, but since we were here till 6 o'clock, we never had
No,
an opportunity
understood,
to
Your
do
Honor.
that.
Understood.
So,
Yeah, I'll come talk to you. No, I'm going to come talk to you. Yes,
you
ma'am.
can come talk to you, then we're gonna have a hearing in a little bit. I've got to get your paperwork
Can I
from,
just say $1,000 then and we'll be done? $1,000?
I'll make that recommendation for you. Yes, ma'am. It'll be up to the judge.
Thank you, sir.
All right.
Thank you. We'll see you in just a little bit.
Yes, Your Honor, Your Honor.
Okay,
All right,
thank
there
you.
we go. Well, I mean, he does.
What was that?
All right. I mean, I don't have a response for that.
I didn't catch what you said.
I don't have a response.
Maybe I shouldn't have heard it.
He said, I seen you all the time.